In this lecture, we shall discuss one of the most important and powerful institutions in this country, judiciary. We will talk about the role played by the judiciary in this country and the controversy surrounding the same. We will be looking at how the judges to the Supreme Court and High Court are appointed, and also the controversy surrounding the appointment of judges to the Supreme Court and High Court, how the judges are removed from their offices, what are the powers of the Supreme Court. We will also be looking at public interest litigation, and whether it is indeed public interest litigation or publicity interest litigation. We will be looking at judicial review, judicial activism, and whether it is judicial activism or judicial adventurism or judicial overreach. We will also be looking at the high courts in this country. We will talk about alternate dispute resolution mechanisms. We will be looking at lok adalats. We will also be looking at why are there crores of cases pending in this country and what can we do about that. And then we will also be looking at whether or not the position of the high courts in this country has been diminished. All this and much more. This is going to be one of the most fascinating chapters in your subject. So let's get started beginning with a brief introduction about judiciary. There is a difference. The traditional role played by the judiciary and the modern role played by the judiciary in this country. What is the traditional role played by the judiciary? To dispense justice. What does that mean? There is a law. This law has been violated by somebody. This individual should be punished. Who will punish this individual? Judiciary. That means if somebody commits murder, dacoity, rape, so many other criminal activities, some institution has got to punish these individuals. And which is that institution? Judiciary. That means the traditional role played by the judiciary was to dispense justice in this country, to dispense justice for those who have been aggrieved, who have been violated, who have been wronged. But now what is the modern role played by the judiciary? The modern role is because of the emergence of a doctrine called doctrine of limited government. What is this doctrine of limited government? Doctrine of limited government says that the powers available with the state, they are not unlimited. There's a limitation on the powers of the state. For example, fundamental rights. Fundamental rights are negatively worded. Fundamental rights are negative obligations on the state. That means when fundamental rights say the state shall not deprive an individual of his life and personal liberty. The state shall not deny equality. The state shall not discriminate. The state shall not do this. The state shall not do that. What is this that the state cannot do? That's the limitation on the powers of the state. But what if this limitation that is imposed on the state is violated by the state? There has to be an institution to protect the fundamental rights of the people of this country, to safeguard and guarantee the fundamental rights to the people of this country, and that is judiciary. That is the Supreme Court. That is why we say Supreme Court is the guardian of our constitution. Supreme Court is the protector of our fundamental rights, the guarantor of our fundamental rights. That's the another role played by judiciary in this country. Then there's another role played by the judiciary, and that is in federal polity. What is this role? Tomorrow there can be a dispute between the state of West Bengal and the state of Jharkhand. There can be a dispute between the state of Tamil Nadu and the state of Karnataka, again on Kaveri issue. Tomorrow there can be a dispute between the central government and one or more states on the other side. That means all these disputes are federal in character. Disputes between the center and the states. Disputes between the states on one side and other states on the other side. All these disputes have to be resolved by some institution, and that is the role played by judiciary in this country, Supreme Court in this country. That means if we look at the idea of Supreme Court, yes, it is the dispenser of justice in this country. Yes, it is the guardian of our constitution. Yes, it is the protector of the fundamental rights of the people of this country. But at the same time, it keeps a check on the powers of the executive as well as legislature. If executive exceeds its brief, judiciary will enter into picture. If legislature exceeds its brief, that means if legislature passes a law which is unconstitutional, if legislature passes a law which is unreasonable, unjust, unfair, judiciary will enter into picture and safeguard the rights and liberties of the people of this country. That is the traditional and the modern role played by the judiciary. But now let's compare our judicial system with the system of United States of America. In India, we say our judicial system is three-tier, and this three-tier is hierarchically organized and organically linked. What does that mean? We have Supreme Court at the top of the hierarchy. Then we have, for every state, a high court. That doesn't mean every state should have one high court, or there should be one high court for every state. I'll discuss this in later parts of this lecture, but there should be high court for every state. But this one high court can be for multiple states as well. It does not mean the Constitution says there should be one high court for every state, but there should be a high court for every state. Confusing? Let me make it simple for you. In India, we have 24 high courts for the union territories and states. That means we have some common high courts as well. We have a high court which is common for multiple states. That means Constitution does not say there should be one high court for every state, but there should be a high court for every state. That means there can be common high courts as well. It doesn't mean only one high court for every state. That's not the case. But what is this three-tier structure? We have Supreme Court at the top of the hierarchy, followed by the high court for every state. Then we have district courts. This is a three-tier judicial structure that we have, which is hierarchically organized, but at the same time organically linked. But what is this organically linked? If you lost the case at the district court level, you can file an appeal before the high court. If you lost this case at the high court, you can file an appeal before the Supreme Court. That's one way of looking at it. Similarly, the judge of a district court can be promoted to a high court. The judge of a high court can be promoted to the Supreme Court, so on and so forth. This is another way of looking at it. We have a judicial system which is three-tier in character, which is hierarchically organized, but at the same time organically linked. But if you look at United States, every state has a Supreme Court. That means, for example, this is Florida. All the cases that are filed by the citizens of Florida, they will end at the Supreme Court of Florida. Then we have a federal court for the entire country as well, for the entire United States as well. But this federal court, normally what it does, it only hears cases of federal character. That means if there is a dispute between the Donald Trump government and there is a dispute with the state of Florida, all these disputes which are federal in character will be heard by this federal high court. Let me make it even simpler for you. In India, if you lost a case in the district court, you can file an appeal in the high court of Karnataka, for example, if you are from Karnataka. If you lost this case, you can file an appeal in the Supreme Court as well. Clear? But if you are in the United States of America, you fought a case at a metropolitan court in a state in Florida, but you lost this case, then you can file an appeal before the Supreme Court of Florida. And if you lost this case there, that is the end of the case, that is the death of the case. Normally, you cannot appeal before the federal court of United States of America. Normally, although there are some cases here and there, but let's not get into that. That means a case which is filed in Florida ends in the Supreme Court of Florida. Then there is a federal court of United States as well. But this federal court normally looks at cases of federal character, federal nature, involving the disputes between the center and the states, between two or more states on one hand and two or more states on the other hand. That is the difference between the judicial structure in India and the judicial structure in the United States of America. But let me tell you something else. There's a fourth tier as well. This fourth tier was created in the year 2009 when Gram Nyalayas Act was passed, and a fourth tier, Gram Nyalayas, was supposed to be set up at every village in this country. So we have a fourth tier structure as well. But there's a difference again. These are constitutional courts created by the constitution of this country, Supreme Court, High Court, District Court. But these Gram Nyalayas, these are statutory courts created by an act of parliament, Gram Nyalayas Act of 2009. So if you have understood this, let's now delve deep into this chapter, judiciary. We will be focusing more on Supreme Court because that is the subject matter for your examination. UPSC focuses more on Supreme Court than any other institution of judiciary in this country. When we will talk about Supreme Court, we will talk about judges, how the judges are appointed, how the judges are removed, what is the controversy surrounding the same, and what are the various concerns with the functioning of the Supreme Court, and what is the way forward. Now let's get started beginning with Article 124 of the Constitution of India. There shall be a Supreme Court of India consisting of Chief Justice of India and not more than 7 judges. That is Article 124 Clause 1 for you. There shall be a Supreme Court consisting of Chief Justice of India and not more than 7 judges. This was 1950. When Constitution was enacted in this country. Later on, the number of judges increased. And if you look at today, we have a Chief Justice of India and 33 judges. And these 33 judges are called puisne judges. other brother judges. Apart from Chief Justice of India, all other judges are referred to as puny judges. That means the system today we have in Supreme Court, we have a Chief Justice of India and then we have 33 judges. That means the current composition of the Supreme Court is Chief Justice of India and 33 judges. Can we increase the number of judges to 51 or 61 or 71? Yes, we can do that. What is the process? For that, Parliament has to pass a law. That means tomorrow, if the composition of the Supreme Court is to be changed, if the number of puny judges are to be increased, yes, we can do that. For that, Parliament has to frame a law, pass a law, enact a law, and increase the number of judges in the Supreme Court. But look at it this way. Constitution says there shall be a Supreme Court of India consisting of Chief Justice of India and not more than 7 judges. Today we have Chief Justice of India and not more than 33 judges. Tomorrow it can be 50 judges or 60 judges, 70 judges. Does that mean this law, which is to be passed by the Parliament, should be a constitutional amendment act? Because we are changing the Constitution. So does that mean Parliament has to pass a constitutional amendment act to increase the number of judges in the Supreme Court? No. Why? Because Article 124 itself says this particular article can be changed. This particular article can be modified. The number of judges can be increased. The number of judges can be changed. How? By passing a parliamentary law. But this law shall not be deemed as an amendment to the Constitution. When this law shall not be deemed as an amendment to the Constitution, that means this law should not be passed by special majority. Pass this law by simple majority, change the number of judges in the Supreme Court, increase the number of judges in the Supreme Court. You don't have to amend the Constitution. You don't have to pass or enact a constitutional amendment act to increase the number of judges in the judiciary. What are we talking about? Judiciary. We talked about the traditional role of the judiciary, the modern role played by the judiciary. And then we compare the judicial structure of India with the judicial structure of the Supreme Court of the United States of America. Now we are talking about Supreme Court. And I told you that Supreme Court consists of Chief Justice of India and not more than 33 judges. But can we increase the number of judges in the Supreme Court? Yes, we can do that. What is the process for that? Parliament should pass a law. But should this law be a constitutional amendment act? No. Pass a law by simple majority and increase the number of judges in the Supreme Court. That means despite the fact that you are changing the Constitution, despite the fact that you are increasing the number of judges in the Supreme Court by altering the words mentioned in the Constitution, but even then it will not be deemed as an amendment to the Constitution. This is one of the flexibilities provided by the Constitution of this country. That is Article 124 clause 1. But then let's look at what are the qualifications required so that an individual can be appointed as the judge of a Supreme Court. Let's look at the qualifications. Number 1, universal qualification. This office is open only for the citizens of this country. But at the same time, this citizen should have a 5 years experience as a judge of one high court or 2 or more such high courts. That means you are a citizen of India. Great. You are eligible provided you satisfy other qualifications. What are these other qualifications? You are a citizen of India and at the same time you have been a judge of a high court or one or more high courts for 5 years. If yes, you are eligible, you are qualified to be appointed as the judge of the Supreme Court. But if you have not been a judge of a high court for 5 or more years, but you have 10 years experience as an advocate of a high court or 2 or more such high courts, even then you are eligible, you are qualified to be appointed as the judge of a Supreme Court. But I am a citizen of this country, but I have not been a judge of one or more high courts for 5 years. That means I'm not qualified. Second, I'm also not an advocate with 10 years experience in one or more high courts in this country. That means even now I'm not eligible to be appointed as the judge of the Supreme Court. But there is a third qualification as well. If you don't have this experience, or you should have this experience. If you don't have even this experience, you should be, in the opinion of the President, in the eyes of the President, a distinguished jurist. This is the qualification required for somebody to be appointed as the judge of a Supreme Court. If you look at High Court, qualification for a High Court judge also is along the similar lines, but with some difference. Number 1, you are a citizen of India. Great. You are one step closer to be appointed as the judge of the High Court. But apart from that, you should have a 10 years experience as a judicial officer. That means maybe you are a magistrate, you are a district judge with 10 years experience. If you are a district judge with 10 years experience, then you are eligible to be appointed as the judge of a High Court. If not, then you have 10 years experience as an advocate in one or more High Courts. Even then, you are eligible to be appointed, you are qualified to be appointed as the judge of a High Court. But there is no concept of a distinguished jurist when it comes to a High Court judge. That means what are the qualifications required for somebody to be appointed to Supreme Court and High Court? The judge of a Supreme Court and the High Court. What are the qualifications? For a Supreme Court judge, you should be a citizen of India. Universal qualification. But at the same time, you should have been a judge in one or more High Courts for 5 years. If not, then you should have been an advocate in one or more High Courts for 10 years. If not, then you should be in the eyes of the President a distinguished jurist. If you satisfy this qualification, you are qualified to be appointed as the judge of the Supreme Court. Let's go back to High Court. A High Court judge should, number 1, first be a citizen of this country. Universal qualification. And at the same time, one of these two qualifications are necessary. What are these qualifications? Number 1, you must have held a judicial office for 10 years. That means maybe a magistrate for 10 years, a district judge for 10 years. If not, then you should have been an advocate in one or more High Courts for 10 years. If you satisfy any of these two qualifications, you are qualified to be appointed as the judge of the High Court. But one important distinction, there is no concept of a distinguished jurist appointed as the judge of a High Court. That is a concept available only with respect to the Supreme Court of this country. So these are the qualifications. Now let's look at how the judges are appointed. If you look at Article 124 clause 2 of the Constitution of this country, it says that the judges of the Supreme Court and High Court, because we are taking High Court and Supreme Court together here. Why? Because the appointment process is same. Appointment process of the judges of the Supreme Court and High Court same. Even the removal process is the same. That is why, so far as appointment and removal is concerned, we will take Supreme Court and High Court together. Constitution says that the judges of the Supreme Court and High Court shall be appointed by the President. How? Constitution says, President, while appointing a judge to a High Court and the Supreme Court, shall consult such of the judges of the Supreme Court and High Courts as the President may deem necessary for the purpose. And these judges of the Supreme Court, they will hold the office till they attain the age of 65. But so far as a High Court judge is concerned, the retirement age is 62. One more important thing, provided in case of a judge other than the Chief Justice of India, the Chief Justice of India shall always be consulted. This is the Constitution of 1950. The 1950 Constitution said, to make it even simpler for you, the President shall be the appointing authority, the judges of the Supreme Court and High Courts shall be appointed by the President. But what is the process? There is a process of consultation. What is this process of consultation? If a Chief Justice of India is to be appointed, the President shall consult such of the judges of the Supreme Court and High Court as he may deem necessary. This is what the Constitution says. That means tomorrow, the President would have appointed me as the Chief Justice of India without consulting anybody. And if somebody would ask the President of India, how can you appoint this individual as the judge of the Supreme Court, as the Chief Justice of India, without consulting anybody? The President could have said, President may deem necessary. I can only consult such of the judges of the Supreme Court and High Courts as I may deem necessary. I did not deem it necessary to consult anybody, and that is why I appointed Mr. Samad Naraj as the Chief Justice of India. This is the plain reading of the Constitution. But what was happening in reality was that the senior most judge of the Supreme Court was appointed as the Chief Justice of India. The senior most judge of the Supreme Court was appointed as the Chief Justice of India. And while other judges of the Supreme Court were to be appointed, this Chief Justice of India was always consulted. So far as a High Court was concerned, when a Chief Justice of a High Court was to be appointed, the President would always consult the Chief Justice of India. When a judge to a High Court was to be appointed, the President would also consult the governor of that state. Because that is what is mentioned in the Constitution of this country. What are we talking about? Appointment process. The plain reading of the original Constitution tells us that Chief Justice of India, when he is to be appointed, the President can consult any judges of the Supreme Court and High Court as he may deem necessary. But if other judges are to be appointed, this Chief Justice of India should always be consulted. But then the President was following a convention. What was that convention? The senior most judge of the Supreme Court should be elevated and appointed as the Chief Justice of this country. And while other judges are to be appointed, Chief Justice of India should always be consulted. And this process worked fine for about 2 decades since the enactment of the Constitution of this country. And then we entered into a period of conflict, and this conflict arose when Indira Gandhi was the Prime Minister of this country. We have discussed Keshavananda Bharti judgment. Keshav Bharti judgment, wherein the Supreme Court said that there is something called basic structure. Parliament has the power to amend any provision of the Constitution, save basic structure. Basic structure cannot be touched, basic structure cannot be removed, basic structure cannot be amended. Apart from basic structure, everything else can be amended by the Parliament. That means restrictions were imposed on the Parliament by the Judiciary, by the Supreme Court. And when Justice Sikri, who was the Chief Justice of India at that point in time in 1973, when his term got over, then the President had to appoint a Chief Justice of India. And what President did, on the advice of the Indira Gandhi government, on the advice of the Prime Minister, Justice A. N. Ray was appointed as the Chief Justice of India. But what was the controversy? In the list of seniority, Justice A. N. Ray was at serial number 4. So if we were following the convention that the senior most judge of the Supreme Court should be appointed as the Chief Justice of India, now we are seeing a conflict. We are seeing a violation of this convention. The President is appointing a judge who is at serial number 4 in the seniority list as the Chief Justice of India. What happened to these 3 judges who were senior to A. N. Ray? They resigned in protest. This was 1973. Come 1975, emergency was imposed in this country. National emergency was imposed in this country. And during the emergency, even habeas corpus was suspended. Even right to life under Article 21 of the Indian Constitution was suspended. Matter went to court. One of the most landmark verdicts in the history of independent India, but should I say one of the most notorious verdicts, infamous verdicts in the history of independent India, ADM Jabalpur case. In this case, 5 judges of the Supreme Court were hearing a matter. What was this matter? The petitioner argued that, dear Supreme Court, we know national emergency is in operation. National emergency is in force. But should habeas corpus be suspended during national emergency? Isn't it that Article 21 is the most important fundamental right in our Constitution? And this Article 21, which deals with the right to life and personal liberty, should never have been suspended, even during emergency. 4 judges of the Supreme Court said, no, the government is right. During emergency, even the habeas corpus will remain suspended. You don't have right to life during national emergency. 1 judge dissented, Justice Khanna. Justice Khanna was then praised throughout the world. Articles were written in praise about Justice Khanna that here is one judge who protested against the illegal authority of the executive, illegal authority of the legislature, dictatorial tendency of the Prime Minister. And this one judge dissented and said, no, habeas corpus is one of the most important features of our Constitution. Article 21 cannot be suspended even during the emergency. But since 4 judges disagreed with Justice Khanna, habeas corpus remained suspended during the emergency. But then Justice Khanna was all set to be appointed as the Chief Justice of India because he was the senior most judge in the year 1976. But then he was superseded. A junior judge was appointed as the Chief Justice of India. Justice Beg was appointed as the Chief Justice of India. And what Justice Khanna did? He did the same thing. What 3 other judges did before him. He resigned in protest. That means we started entering into a period of conflict. And this was the period when Indira Gandhi gave a slogan of committed judiciary. Why? We have discussed in Directive Principles of State Policy that when bank nationalization was carried out by Indira Gandhi government, the court struck it down and said, no, this is violation of fundamental rights in this country. She also tried to abolish privy purse, but then the Supreme Court said, this is violation of right to property, Privy Purse Abolition Act is unconstitutional. Indira Gandhi thought that we should have judges in the judiciary who are committed to the ideology of the political party which is running the government. That means if the ideology of the political party running the government is that banks should be nationalized, the judges should support the government. If the ideology of the government is that privy purses should be abolished, we should have judges, committed judges in the judiciary who should abide by the decisions of the party, of the government. That means we should have committed judiciary in this country. Till about 1970s, the early 1970s, judiciary was following a practice called judicial restraint. That means whatever executive is doing, they may be doing right. We will not enter into the domain of the executive. We will not interfere in the legislative process. That is the ideology of the judiciary in this country. Till early 1970s was judicial restraint. We will exercise restraint when it comes to the matters of executive and legislature. But then the controversy arose again when judges were superseded, when the slogan of committed judiciary was given by the Congress party in the 1970s, and then we are entering into a period of conflict. A petition was filed in the Supreme Court. This is widely known as the first judges case, or S.P. Gupta versus Union of India, 1981. 2 important questions or issues were raised by the petitioner in this case. Number 1, the definition of the word consultation. And can judges be transferred even against their will? What is this consultation? If you look at Article 124 of the Constitution says, while appointing judges, the President shall consult Chief Justice of India. The issue before the Supreme Court in S.P. Gupta case was, is this word consultation same as concurrence? Does the word consultation mean concurrence? Then what is the difference? Consultation is, let's say for example, am I going too fast when I'm teaching you? I'm consulting you because you are my student. You can say, no sir, your speed is right. Somebody would say, no, you're speaking slightly fast, please slow it down. I'm consulting you. But whatever feedback you're giving me, that's not binding on me. You're saying, sir, you're going too fast, I will go even faster. And I will speak loudly, fastly, I won't accept whatever recommendation you are giving me. That is consultation. But if it is concurrence, I'm asking you, am I going too fast? You're saying, yes sir, you're going too fast. I have to slow down now because this is concurrence. I have to abide whatever you are telling me. This was the question issued before the Supreme Court. When Constitution says Chief Justice of India should be consulted by making appointments to the Supreme Court and High Court, is this word consultation same as concurrence? Supreme Court said no. Consultation does not mean concurrence. That means the President should always consult Chief Justice of India. But whatever name is recommended by the Chief Justice of India, that is not binding on the President of India. President can violate. President can go against the consultation with the Chief Justice of India as well. Issue number 2. Can the judge of a High Court be transferred from one High Court to another High Court, even against their will? Because in 1970s, if there was a judge at a High Court who was unfavorable to the government, unfavorable to the political party in power in that state, this judge was transferred from that state to another state, even against the will of this judge. Supreme Court said yes. A judge can be transferred from one High Court to another High Court, even against their own will. So this was 1981 judgment S.P. Gupta versus Union of India. This is popularly called as first judge's case. But whatever Supreme Court said in 1981, it completely reversed its position in 1993. A case was filed in the Supreme Court. This is what we call second judge's case. An organization called SCARA, Supreme Court Advocates on Records Association. This organization filed a petition in the Supreme Court in the year 1993. And now let's look at what Supreme Court said in this second judge's case, which deals with the appointment of judges to the judiciary. Supreme Court said consultation is equal to concurrence. In 1981, Supreme Court said consultation does not mean concurrence. But now in 1993, Supreme Court is completely reversing its original judgment and saying now consultation means concurrence. Supreme Court said this appointment process is a very important process because we have to appoint judges with impeccable integrity. We have to appoint judges with the right talent to the judiciary. And that is why this appointment process should be consultative in character. Supreme Court said that the appointment of judges to the higher judiciary is an integrated, consultative, and participatory exercise to select the best possible talent to the judiciary. And that is why the opinion of the Chief Justice of India enjoys primacy. What Supreme Court said, appointment of judges to the higher judiciary should be an integrated, participatory and consultative exercise. The President shall consult the Chief Justice of India and the opinion of the Chief Justice of India enjoys primacy. Why? Because we have to select the best possible talent to the higher judiciary. Supreme Court said, if there is a vacancy in the Supreme Court, the sole authority which will be responsible for filling up of this vacancy is the Chief Justice of India, not the government. If there is a vacancy in the High Court, the sole authority responsible for filling up this vacancy is the Chief Justice of that High Court. But Supreme Court said one more thing. Supreme Court said when we are talking about appointment of judges is an integrated, participatory exercise. President consulting only Chief Justice of India is not a participatory exercise. The President shall have to consult plurality of judges. What does that mean, plurality of judges? That means Chief Justice of India plus 2 senior most judges of the Supreme Court. In Supreme Court, we have a hierarchy. There is Chief Justice of India, then the senior most judge, next, so on and so forth. Supreme Court said, if this appointment process is to be integrated, participatory, and consultative, you can't always and only consult Chief Justice of India. You have to consult plurality of judges, more judges. So you should consult Chief Justice of India and two senior most judges of the Supreme Court. And this is the origin of collegium system of judicial appointments. Supreme Court said, the President, while appointing judges to the High Court and the Supreme Court, shall consult this collegium. And whatever name is recommended by the collegium to the President, this individual should be appointed. How? If this collegium recommends name A, that A should be appointed to the Supreme Court or High Court, the President shall have to appoint this individual. Can President say no? President can't say no. But President can refer this name back to this collegium for reconsideration. President may ask this collegium, please reconsider this name, and because of these reasons, I'm giving you cogent reasons, legitimate reasons why you should reconsider this name. Please reconsider this name. But if the same name is recommended again by the collegium to the President, President has no other option but to appoint this individual as the judge of the Supreme Court or High Court. That means virtually now, because of this 1993 judgment, judges are appointed by themselves. That means in original Constitution said, President shall appoint judges to the High Court and the Supreme Court after consulting such of the judges of the Supreme Court and High Court as he may deem necessary. Now 1993 judgment is saying, no, we will tell you whom to consult. You have to consult plurality of judges. You have to consult Chief Justice of India and two senior most judges of the Supreme Court. And whatever name is recommended by this collegium, that is binding on the President. You may ask for the reconsideration of this name, but only once. If the same name is recommended again, President has no other option but to appoint this individual. That means complete reversal. The original position in 1950, then S.P. Gupta judgment in 1981, complete reversal in 1993. This is the origin of collegium system of judicial appointments. Then came another judgment in 1998. Reappointment of judges 1998. What is this presidential reference? Then government realized that in 1981, the Supreme Court said consultation does not mean concurrence. But in 1993, Supreme Court is saying consultation means concurrence. Supreme Court is saying Chief Justice of India alone, single individual should not be consulted. You have to consult Chief Justice of India and two senior most judges of the Supreme Court. So there's a lot of confusion. The government asked the President, the dear President, under Article 143 of the Constitution of India, Supreme Court is your advisor. Please refer this matter of appointment of judges to the Supreme Court and High Court. Please refer this matter to the Supreme Court and ask the views of the Supreme Court on this matter because there seems to be a lot of confusion about how the appointment process should take place. Please give us some clarity. And that is how, in 1998, a presidential reference was sent to the Supreme Court asking the views of the Supreme Court on this matter. And what is this matter? Appointment of judges. Justice Verma was the Chief Justice of India at that point in time. And what Supreme Court said in this matter? Supreme Court said, number one, consultation is concurrence. Absolutely making it clear, crystal clear, that Chief Justice of India, when you consult, the primacy is enjoyed by the Chief Justice of India. Consultation means concurrence. Whatever name is recommended by the Chief Justice of India, by the collegium to the President, that is binding on the President. But Supreme Court said, you can't only consult the Chief Justice of India and two senior most judges of the Supreme Court. What you have to do, if judges to the Supreme Court are to be appointed, collegium will consist of Chief Justice of India plus four senior most judges of the Supreme Court. Whatever name is recommended by this collegium, that is binding on the President. So, okay, anything else here, Supreme Court? The Supreme Court told the government lawyer, wait, if a High Court judge is to be appointed, consult Chief Justice of India plus two senior most judges of the Supreme Court. Dear Supreme Court, anything else? No, please wait. If you have to transfer a judge of a High Court from one High Court to another, consult Chief Justice of India plus four senior most judges of the Supreme Court plus two Chief Justices of High Court as well. Who are these two Chief Justices? There is a judge. He is to be transferred from Calcutta High Court to Madras High Court. While transferring this judge from one High Court to another High Court, consult these senior judges, and apart from these senior judges, consult the Chief Justice of the sending High Court, Chief Justice of the receiving High Court as well. The government lawyer asked the Supreme Court, dear Supreme Court, you are completely changing the composition of the collegium. In 1981 you're saying something, in 1993 you're saying something, and now in 1998 you're saying completely different. If the original Constitution says the President shall consult Chief Justice of India, how can you say that Chief Justice of India alone should not be consulted? You have to consult plurality of judges. You have to consult four judges, sometimes two judges, sometimes two Chief Justices of High Court as well. What are you doing? Supreme Court said, who is the final interpreter of the Constitution? Supreme Court. Supreme Court said, Constitution talks about Chief Justice of India. But Chief Justice of India is not an individual. Chief Justice of India is an institution. So if you are consulting only the Chief Justice of India, who is a person, it won't be consultation. You have to consult the institution of Chief Justice of India. And this consultation will be proper only if you consult plurality of judges, more than one judges. Supreme Court further said, if more than one of these members, they disagree upon a name, this name cannot be sent to President for appointment. That means if this collegium is recommending the name A, debating upon the name A, collegium is debating whether Sarmat Baraj should be appointed as the judge of the Supreme Court. If more than one of this collegium member says no, Sarmat Baraj cannot be appointed to the Supreme Court, my name cannot be recommended to the President for appointment. Clear? As simple as that. Supreme Court said one more thing. Supreme Court said any name which is not acceptable to Chief Justice of India cannot be sent to the President for appointment. That means in appointment process, Chief Justice of India enjoys a virtual veto. Any name which is not acceptable to Chief Justice of India cannot be sent to the President for appointment. Supreme Court said something else. Supreme Court said that if the name recommended by the collegium is sent to the President for appointment, President shall appoint this individual. But if President wants, President can send the name back to the collegium for reconsideration. But giving in writing cogent reasons, legitimate reasons why you want the collegium to reconsider this name. And if this name is reiterated, if this name is again recommended by the collegium to the President, President will have no other option but to appoint this individual. That means perhaps India is the only country in the world where judges are appointed by themselves. Later on, the Supreme Court was asked to justify this collegium system of judicial appointments. Many people criticized the judiciary for starting this collegium system because it is not mentioned anywhere in the Constitution. But Supreme Court justified the collegium system of judicial appointments. Number one, on the grounds of judicial independence. Supreme Court said, look at what happened. Various Supreme Court judges who spoke with the media later on said, look at what happened in the 1970s. Committed judiciary. The judges were superseded. The judges who did not toe the line of the government were not appointed as the Chief Justice of India. So we had to remove the influence of the executive because separation of powers is part of the basic structure of Indian Constitution. That is why for judicial independence, for judicial autonomy, for the independence of judiciary, we had to take this decision. Supreme Court judges said something else. Look at the vacancies in various high courts in this country. The government is dilly-dallying. The government does not want to fill these vacancies. That is why we say, if there is a vacancy in the High Court, the Chief Justice of that High Court is authorized to fill that vacancy. If there is a vacancy in the Supreme Court, the Chief Justice of India will initiate the filling up of this vacancy. That is how we can fill the vacancies in the judicial system, and that is how these crores and crores of cases which are pending in this country can be lessened. These were the arguments presented by the judiciary justifying the collegium system of judicial appointments. But now let's look at the criticism of this collegium system. Criticism number one, if you look at today, 427 vacancies are there in various high courts in this country, despite the fact that there is collegium system. So if the argument of the Supreme Court judges was that there are vacancies in various high courts, they want to speed up the process of filling up of these vacancies. That is why we have to start this collegium system of judicial appointments, despite the fact that today we have collegium system. Why is it that 427 vacancies exist in various high courts in this country? Not just that. Times of India came up with a report and said the process of filling up of these vacancies might take 15 years because every year the judges retire as well. This collegium system lacks transparency and accountability. When collegium system, they come together, Chief Justice of India, four senior most judges of the Supreme Court, they sit together and they decide that A, B, C, and D shall be appointed as the judges of the Supreme Court and High Court. These four names shall be sent to the President for appointment. But on what grounds are these four candidates judged? We don't know. The entire process lacks transparency. The entire process lacks accountability. For example, we have a judge named Justice Padiwala. He was a judge of the Gujarat High Court. Justice Padiwala said that there are two problems plaguing our country, which is responsible for making India backward. One is corruption, and nobody can disagree with that. Yes, corruption is an evil, corruption is a process, corruption is what is keeping us backward. Second, he said, reservation. Reservation is one of the most important tools of social justice. Social justice is part of the basic structure of Indian constitution. So here is a judge who is the protector of our fundamental rights, who is the guardian of our constitution, because he's part of the judiciary. Judiciary is the guardian of our constitution. Here is this judge who says one of the most important tools of social justice, reservation, is responsible for keeping India backward. And this judge was appointed. This particular individual with such a mindset, with such ideology, was appointed as the judge of the High Court. That means when this collegium system sits together, how do they judge whether this individual is fit enough to be appointed as the judge of the High Court or the Supreme Court? Does this collegium system check the constitutional philosophy of a judge? Does this collegium system look at the various judgments given by this judge? Then he should be appointed, then he should be promoted to the Supreme Court. While lawyers are discussed, debated in these collegium meetings, whether these lawyers, whether they have taken up any cases pro bono, that means in larger public interest, whether this particular advocate who is recommended to the President for being appointed as a judge of the Supreme Court or the High Court, is this advocate taking up cases pro bono in larger public interest without charging any fee? Then these are the considerations that collegium system should keep in mind while recommending names to the President. But the problem is we don't know. This entire process lacks transparency, lacks accountability, because we don't know on what parameters these individuals are judged and then recommended to the President for appointment. That is something that we don't know. But perhaps the biggest criticism of collegium is that it violates the Constitution. How? Original Constitution said, President shall consult Chief Justice of India. Where is it mentioned that consultation is concurrent? Original Constitution said, while appointing judges to the High Court, the President shall consult Governor of that state as well. Is Governor part of the collegium? No. That means this collegium system is against the very principle of our Constitution. Constitution said, the President shall consult such of the judges of the Supreme Court and High Court as he may deem necessary. That means the President could have consulted a junior judge of the Supreme Court as well, if he's very talented. But now here the collegium says, Chief Justice of India and four senior most judges of the Supreme Court. Why can't a junior most judge of the Supreme Court also be consulted by the President if he deems fit? That means this collegium system is violative of the original Constitution as well. But I will tell you a few more criticisms of the collegium system. If you look at after the origin of the collegium system in 1993, only the judges of the High Court or the advocates of the bar are appointed, are promoted to the Supreme Court. Only the advocates are promoted to the High Court, to the Supreme Court. But look at what happened prior to 1993, when the executive had the most important role in the appointment process. In the pre-collegium era, we had someone like V.R. Krishna Iyer, who was the judge of the Supreme Court, appointed by the President before collegium system. And do you know who this V.R. Krishna Iyer was? He was also a minister in a communist government in Kerala. When the communist government was dismissed there, he joined the bar, practiced law, took up various cases pro bono, then was subsequently promoted, was appointed as the judge of the Supreme Court, and Justice V.R. Krishna Iyer is one of the most popular judges throughout the world from India. His judgments have been cited by judges of foreign countries. His judgments have been cited by International Court of Justice. It was Justice V.R. Krishna Iyer, together with Justice P.M. Bhagwati, who started public interest litigation in this country. It was Justice V.R. Krishna Iyer who said jail is an exception, bail is the norm. It was Justice V.R. Krishna Iyer who started jail reforms in this country. So Justice V.R. Krishna Iyer, one of the most important judges in the history of judicial structure in this country, he was not the product of collegium system of judicial appointments. But can we today envisage someone, a former politician, being appointed as the judge of the Supreme Court or the High Court? Perhaps not. Look at the United States of America. William Howard Taft. Do you know who he was? He was the president of the United States of America. And after his term got over, he decided to contest for the second term, but he was defeated by President Woodrow Wilson. But then after that, he was appointed as the Chief Justice of the Supreme Court of the United States of America. The only person to hold two offices, President of the United States of America, and later on, the Chief Justice of the United States of America as well. Such is the appointment process in different parts of the world. But in India, we never look beyond the judges of the High Court and the advocates of the Supreme Court for being appointed to the higher judiciary. That is another problem with this collegium system. Now we may disagree, saying we should not have politicians being appointed as the judges of the Supreme Court. But there are some politicians who are top-notch lawyers, top-notch judicial minds in this country, and they can do wonders if they are appointed as the judges of the High Court and the Supreme Court as well. But perhaps the biggest criticism of the collegium system was leveled by a two-judge bench of the Supreme Court itself. In case Suraj India Trust 2010. In this case, a two-judge bench of the Supreme Court is asking certain questions, some specific questions to the Chief Justice of India, and asking answers from the Chief Justice of India. Question number 1. When the two decisions of this court in 1993 and 1998 really amount to amending Article 124, Clause 2 of the Constitution? Because Article 124, Clause 2 said that while appointing judges to the Supreme Court and High Court, the President shall consult such of the judges of the High Court and Supreme Court as he may deem necessary. Where is it mentioned that the President should consult Chief Justice of India and four senior most judges of the Supreme Court? Does that not mean that 1993 judgment and 1998 judgment, which started collegium system in this country, through these judgments you have amended Article 124 of the Constitution? That's question number 1. Question number 2. Is there any collegium system mentioned anywhere in the Constitution? Please answer. Can the Constitution be amended by a judicial verdict or only by the Parliament according to Article 368? That means can Constitution be amended by judiciary or can Constitution be amended only by Parliament under Article 368? If only by the Parliament under Article 368, then is it not true that these two judicial verdicts of 1993 and 1998 has amended the Constitution of this country? In the constitutional scheme of things, can judges be appointed through consultation with the executive or can judiciary alone make the appointments? Please give us an answer. Does the word consultation in Article 224, which deals with the appointment of High Court judges, does it mean concurrence? Please tell us. Few more questions. By judicial interpretation, can words of the Constitution be made redundant? How? While appointing a High Court judge, original Constitution said the President shall consult the Governor of the state as well. In our existing collegium system, where is Governor? Is Governor consulted at all? Does it not mean that through judicial orders, through judicial verdicts, you are making some of the words and lines mentioned in the Constitution redundant? Can you do that? Please answer. Many other questions were asked by the two judges of the Supreme Court in this Suraj India Trust case to the Supreme Court Chief Justice of India, but till date, there have been no answers to these questions posed by the Supreme Court itself to the Chief Justice of India. But after these 1993 and 1998 verdicts, various governments, starting with Atal Bihari Vajpayee, later on Dr. Manmohan Singh, then Prime Minister Modi as well, they started to implement an idea of NJAC, National Judicial Appointments Commission. So instead of collegium system appointing judges to the Supreme Court and High Court, recommending names to the Supreme Court and High Court, we should have a different body called NJAC, which should recommend names to the President for being appointed as the judges of the Supreme Court and High Court. And this NJAC, National Judicial Appointments Commission Act, was passed by the Parliament in the year 2015. NJAC said it consists of Chief Justice of India, two senior most judges of the Supreme Court, the Law Minister, and two eminent persons. These two eminent persons shall be appointed by a panel of Prime Minister, Chief Justice of India, and leader of opposition in Lok Sabha, or leader of the single largest party in Lok Sabha. That means instead of collegium, this NJAC should recommend names to the President for being appointed as the judge of the High Court and the Supreme Court. NJAC would consist of Chief Justice of India, two senior most judges of the Supreme Court, the Law Minister, two eminent persons. And these two eminent persons shall be appointed by this committee, and this committee will recommend names of these two eminent persons, and this NJAC will perform the role of collegium system. That means what is the role of the collegium system? To recommend names to the President for being appointed as the judges of the Supreme Court and High Court, to recommend who is going to be the Chief Justice of India, to recommend the transfer of judges from one High Court to another High Court, all the decisions, all the functions of the collegium should now transfer to NJAC. And NJAC would recommend names to the President. Many people praised NJAC. Many people said that look at the composition of this NJAC. We have judges, members from the judiciary. We have a law minister who is part of the executive. We have two eminent persons. They are part of the civil society. So everybody is represented. Everybody is accepted here. And many people thought that NJAC is much better way of appointing judges than this collegiate system. But then a case was filed in the Supreme Court challenging the constitutional validity of NJAC, National Judicial Appointments Commission, and Supreme Court said NJAC is unconstitutional. When NJAC is unconstitutional, that means we will go back to collegium system of judicial appointments. And even today, we have a collegium system of judicial appointments. But why did Supreme Court say NJAC is unconstitutional? Two things. Number one, NJAC is unconstitutional because it violates independence of judiciary, and independence of judiciary is part of the basic structure of Indian Constitution. Supreme Court said, look at the composition of NJAC. It is tilted against judiciary. We have a law minister, we have two eminent persons, and since the members are dominated by non-judges, independence of judiciary is getting violated. Since independence of judiciary is part of the basic structure of Indian Constitution, that is why NJAC is unconstitutional. Supreme Court said something else. Supreme Court invented another basic structure doctrine. Supreme Court said primacy of Chief Justice of India in judicial appointments is getting violated. Since primacy of Chief Justice of India in judicial appointments is part of the basic structure of Indian Constitution, that is why NJAC is unconstitutional. Because in this NJAC, CJI did not have a veto. In 1993 judgment, in 1998 judgment, I have told you clearly that Supreme Court said any name which is not acceptable to Chief Justice of India cannot be sent to the President for appointment. Because in appointment process, Chief Justice of India enjoys a virtual veto. But this NJAC, it does not provide virtual veto to Chief Justice of India, and since primacy of Chief Justice of India in judicial appointments is getting violated, and this primacy of Chief Justice of India in judicial appointments is part of the basic structure of Indian Constitution, that is why NJAC is unconstitutional. But now let's critically analyze this NJAC judgment, and let's discuss why this NJAC judgment, where the Supreme Court said NJAC is unconstitutional, it is a deeply flawed judgment of the Supreme Court. Let's look at the reasons. Number one, Supreme Court said independence of judiciary is getting violated, and since independence of judiciary is getting violated, that is why NJAC is unconstitutional. But if you look at NJAC, look at the composition, it is tilted in favor of judiciary. How? NJAC said if two or more members of this NJAC, they do not agree on a name A, then this name A cannot be sent to President for appointment. That means this NJAC, in this NJAC's meetings, these members of the judiciary would have blocked any name if it is not acceptable to them. That means if these two eminent persons, this law minister would recommend a name A, but this name A is not acceptable to the judiciary, all they have to do is block this name. And ultimately, this name cannot be sent to the President for appointment. Then how does NJAC violate the independence of judiciary when the composition of NJAC is tilted in favor of judiciary? We have three members from the judiciary, Chief Justice of India and two senior most judges of the Supreme Court. In fact, these two eminent persons are also to be appointed in consultation with the Chief Justice of India. So the composition of NJAC is tilted in favor of judiciary. So how can NJAC violate the independence of judiciary? Another argument. If NJAC violates the independence of judiciary, do you know which is the biggest violator of the independence of judiciary? The original constitution. Original constitution only gave a consultative role to the judiciary. Original constitution only said that judges are to be appointed in consultation with the Chief Justice of India, in consultation with other judges. But NJAC is not only providing consultative role, it is providing deliberative role to the judiciary. It is providing more important role to the judiciary. So if NJAC violates the independence of judiciary, then the biggest violator of the independence of judiciary is the original constitution itself. When constitution was being drafted, B.R. Ambedkar said judiciary is one of the most important institutions in this country. But even then, even if it is one of the most important institutions in this country, because according to B.R. Ambedkar, CAG is the most important office under the constitution. After that, it is the judiciary. B.R. Ambedkar said even if judiciary is one of the most important institutions in this country, but even then, we cannot give it more powers so that it becomes a monster. So we have to still keep a check on judiciary. And how can we keep a check on judiciary? Through appointment and removal. How appointment? Judges are to be appointed by the President, that means the executive, and judges are to be removed by the President, but based on the resolution passed by the legislature. And we will discuss the process slightly later. B.R. Ambedkar said it is through this appointment and removal process that we can keep a check on the judiciary. And that is how we can implement doctrine of checks and balances in our constitution. And that is why B.R. Ambedkar said, despite the fact that judiciary is one of the most important institutions in this country, we cannot leave the appointment process to judiciary. That is why we have to keep a check on judiciary. But now let's look at this independence of judiciary argument of the Supreme Court in more detail. How has NJAC violated the independence of judiciary? For that, we have to understand that there are very important principles mentioned in our constitution which provide independent character to our judiciary. What are these important points? Number one, in our constitution says that the judges of the Supreme Court and High Court, they do not hold office during the pleasure of the President. That means they hold office till they attain a specific age. Supreme Court judge till they attain the age of 65. High Court judge till they attain the age of 62. So the judges of the Supreme Court and High Court, they do not hold office during the pleasure of the President. They hold office for a specific term. Was NJAC snatching this independent feature from the judiciary? No. Number two, the salaries, allowances of the judges of the Supreme Court and High Court, they are charged on the Consolidated Fund of India. When they are charged on the Consolidated Fund of India, that means they are not subject to the vote of the Parliament. That means despite the fact that the budget is not passed, even then, the judges of the High Court and the Supreme Court will get their salary. The salaries of the Supreme Court judges charged on the Consolidated Fund of India. The salaries of these High Court judges charged on the Consolidated Fund of the state, not subject to the vote of the legislature. This is the independence that Constitution gave to the judiciary. NJAC did not snatch that. NJAC did not say that now judges will hold office during the pleasure of the President. NJAC did not say that the salaries of the judges is not charged on the Consolidated Fund now. NJAC did not say that. What is the other independent feature provided by the Constitution to the judiciary? Look at Parliament. Inside Parliament, the members of the Parliament, they have absolute freedom of speech and expression. They can say whatever they want to say and they will not be held accountable for what they say. But there is one restriction. They cannot discuss the conduct of judges. It is only when a motion is pending in the Parliament and this motion calls for the removal of a judge. Only when this type of motion is pending, then Parliament can discuss the conduct of this judge who is to be removed by the Parliament. Apart from that, the conduct of judges cannot be discussed in the Parliament. NJAC did not snatch this. NJAC did not say that now the conduct of judges will be discussed in the Parliament. NJAC did not say that. Powers are conferred on the High Court to punish for contempt of itself. This power was not snatched by NJAC. NJAC did not say now the High Courts and the Supreme Court cannot punish people for contempt. More specifically, the judges of the High Court and the Supreme Court are removed through a very complicated process. And it is such a complicated process that till date, no judge of the Supreme Court and the High Court has been removed from their offices. NJAC did not snatch this feature. That means when Supreme Court says NJAC is unconstitutional because it violates the independence of judiciary, here are the features which provide independent character to our judiciary. And none of these features were touched by NJAC. So how can NJAC violate the independence of judiciary? But now let's look at these two paragraphs very closely and I will read them out. But as valued as judicial independence was to the Constituent Assembly, which drafted the Constitution of India, it did not see the vesting of the ultimate power of appointing judges on the executive as an infraction of that principle. That means if executive is given the power of appointment, it does not mean the independence of judiciary is getting violated. No. But the Constituent Assembly viewed such a power as a vital cog in the checks and balances required to ensure a proper separation of powers. That's something that we discussed. One more important paragraph. When Parliament enacted NJAC, Parliament did not snatch the independent character of the judiciary. But what Parliament did, Parliament merely tried to go back to the original constitution. Parliament merely tried to recalibrate this process in such a manner that there is checks and balances put in place. Let's look at this paragraph. Parliament merely sought to realign the process of appointments in consonance with the general principle of separation of powers. Given that the originally enacted constitution placed overriding power on the executive to make judicial appointments, it is unfathomable how the proposed system, NJAC, how this system, which accords judiciary not merely a consultative role, but a determinative role, because NJAC, the composition of NJAC is tilted in favor of the judiciary, and now judiciary will determine who will be appointed to the High Court and the Supreme Court. So it is unfathomable how this NJAC, which gives determinative role, can be found to infringe the independence of the judiciary. This is the criticism of the NJAC judgment of the Supreme Court in 2015. But when this judgment was given by the Supreme Court in 2015, the Supreme Court accepted, yes, our collegium system is not without flaws, but we are seeking suggestions from you. How can we better make this collegium system? How can we better reform this collegium system? Please give us your suggestions. Suggestions were given, but not implemented by the judiciary. Only thing that was implemented was that Supreme Court will, on its website, put out the names of all those people who are appointed to the Supreme Court and High Court. But we can get this detail even from newspapers. Newspapers tell us who has been appointed to the Supreme Court, who has been appointed to the High Court. What the real reform would have been, why the name A was not sent to the President for appointment, even if you were discussing this name. What led to person A being rejected by the collegium system? Please tell us that. On what grounds are you judging and testing the suitability of a candidate for being appointed to the High Court and the Supreme Court? That is what we want to know. So the reform cannot be that these names we discussed and these names have been recommended to the President for appointment and we are putting out these names on our website. We can get these details from the newspapers as well. What we want is that why these names were recommended, on what grounds. We want why a particular name which you considered for the collegium system, but you did not recommend him. That is the transparency that we want. When this NJAC judgment was given, there was one judge who disagreed. Justice Talameshwar. Justice Talameshwar said, I do not agree with this NJAC judgment. I believe executive has a very important role to play in judicial appointments, so I do not agree that NJAC violates the independence of judiciary. But since 4 other judges disagreed with Justice Talameshwar, collegium system was given a rebirth, NJAC was declared unconstitutional. One such member was Justice Korean Joseph, who said NJAC violates independence of judiciary. But now he has given a statement and he has said, after his retirement, Justice Korean Joseph has now said that I regret my NJAC judgment. I believe I erred when I said NJAC violates the independence of judiciary. That is what you need to know, the appointment of judges to the Supreme Court and High Court. Now let us look at the powers of the Supreme Court, or should we say the jurisdiction of the Supreme Court. And we have divided the jurisdiction of the Supreme Court into various categories. For example, original jurisdiction, appellate jurisdiction, revisory jurisdiction, advisory jurisdiction, so on and so forth. And now let's look at all these different types of jurisdictions one by one, beginning with original jurisdiction. We'll talk about the meaning of original jurisdiction, we'll talk about the exceptions to original jurisdiction. When we talk about original jurisdiction, we will also talk about original exclusive jurisdiction. What is the difference between original and exclusive jurisdiction? What is original jurisdiction? These types of cases can be originally filed in the Supreme Court. What does that mean? Normally, I filed a case in the district court, I lost the case. I filed an appeal before the High Court, I lost this case. Then I filed an appeal against this High Court judgment in the Supreme Court. That means this particular case was not directly filed in the Supreme Court. This particular case was first filed in the district court, then High Court, then Supreme Court. All those types of cases that are and that can be directly filed in the Supreme Court, that is what we call the original jurisdiction of the Supreme Court. That means these cases get filed directly in the Supreme Court. Then there is something called exclusive jurisdiction. There are certain cases that can be filed in district courts, High Courts, and then in Supreme Courts. But there are certain cases that no one else can hear except the Supreme Court. That means these types of cases are exclusively filed in the Supreme Court and no other institution can hear such cases. Original, exclusive jurisdiction. Let's look at the examples. Article 131. The Supreme Court has the original jurisdiction in any dispute between the government of India and one or more states. That means basically disputes of federal character, federal nature. Disputes between the center and the states cannot be filed in any other court but directly in the Supreme Court. Supreme Court has the original jurisdiction of this matter. Between government of India and any state or states on one side, there is government of India, two or more states on one side, and one or more states on the other side. This also is the original jurisdiction of the Supreme Court. That means such cases can be directly filed in the Supreme Court. Disputes between two or more states, dispute between Karnataka and Tamil Nadu, directly filed in the Supreme Court. Original jurisdiction. The court has original jurisdiction when it has the authority to hear and determine a case in the first instance. In the first instance, that is what we call original jurisdiction. Because if it is the second instance, then it's an appeal. You file a case in the Supreme Court, but this case is basically an appeal against the judgment of the High Court. That means this case is not filed in the Supreme Court in the first instance, but this case is filed in the Supreme Court as a matter of appeal against the judgment of the High Court. That means it's not an original jurisdiction. A court has the original jurisdiction when it has the authority to hear and determine a case in the first instance. It has an exclusive jurisdiction when it has the authority to hear and determine a case which no other court can hear or determine. But there are some exceptions to original jurisdiction. What are these exceptions? Number one, treaty of pre-constitutional era. That means there are some treaties which the government of India has signed with other countries or with other institutions prior to the commencement of the Constitution. That means prior to 1950. For example, the instrument of accession signed between the Maharaja Hari Singh and the government of India headed by, at that time, Lord Mountbatten. This is a pre-constitutional treaty. This is a pre-constitutional agreement. This is a pre-constitutional sanad, as it is called. Now, if there is a dispute on the instrument of accession, this case cannot be filed in the Supreme Court. That means Supreme Court does not have the original jurisdiction on these pre-constitutional era treaties. That means Constitution has made a very conscious decision to keep these matters within the exclusive jurisdiction of the executive. These matters should be dealt by the executive, should not be dealt by the judiciary. Second, Article 262. That means involving disputes, water disputes, interstate water disputes. That comes under Article 262. That means such cases also, there is an exception to the original jurisdiction of the Supreme Court. But then you will say, if interstate river water disputes, the Supreme Court does not have the original jurisdiction. Why is it that on Kaveri matter, the Supreme Court is again and again hearing these cases? There are various arguments on that. Number one, basically these are not original jurisdictions, but these are appellate jurisdictions. Appellate jurisdiction, basically there is an interstate river water tribunal. A tribunal which is set up specifically to deal with interstate river water disputes. This tribunal has given an award, this tribunal has given a ruling, this tribunal has given a verdict, but this verdict is not acceptable to Tamil Nadu. This verdict is not acceptable to Karnataka, for example. Then Karnataka or Tamil Nadu can file an appeal against this verdict of this tribunal in the Supreme Court. That is how Supreme Court is hearing these Kaveri matters. That's another argument. Supreme Court sometimes has accepted these interstate river water petitions originally, that means directly, bypassing the tribunal. How can Supreme Court do that? The argument is that the petitioners are filing a case under Article 21 of the Indian Constitution, a right to life and personal liberty. Sometimes a right to life is dependent upon this Kaveri river, this water of the Kaveri river. So if there's a petitioner who is filing a case in the Supreme Court under Article 21 of the Indian Constitution, which is a fundamental right, Supreme Court cannot refuse a petition which is filed under Article 21 of the Indian Constitution. That is how Supreme Court is hearing these matters. But so far as your preference is concerned, under original jurisdiction, there are some exceptions. If it's a pre-constitutional treaty, there is no original jurisdiction. Interstate river water disputes under Article 262, there is no original jurisdiction of the Supreme Court. Matters related to Finance Commission, exclusive original jurisdiction is not there. Similarly, adjustment of certain expenses between the Union and the states under Article 290 of the Indian Constitution. For example, they were the officers of the British Empire prior to the independence of this country. Now, after the British Empire was over, India got independence, we gave ourselves a constitution. What will happen to these posts and positions? Should Indian government pay salary to these employees, or should these offices be abolished? If these offices are to be abolished, should there be a compensation provided to these officers? On all these matters, Supreme Court will not have any jurisdiction, no original jurisdiction for the Supreme Court on these matters. That means original jurisdiction is such where a particular case can be directly filed in the Supreme Court in the first instance, but there are some exceptions, and these are the exceptions to original jurisdiction. Now, let's look at another jurisdiction, appellate jurisdiction. Basically, Supreme Court is the highest court of appeal, and this is something that we have discussed many times. You file a case in the district court, you lost it. You file an appeal against the judgment in the High Court, you lost it. Then the highest court of appeal is the Supreme Court. This is what we call appellate jurisdiction. But this case can be of three types. This case can be either a civil case, can be either a criminal case, can be either a constitutional case. Let's look at the appellate jurisdiction when it comes to civil case, criminal case, and constitutional case one by one. Let's look at a constitutional matter. For example, I filed a case in the High Court of Karnataka, and the High Court of Karnataka dismissed my petition and I lost this case. Then I'm applying for a certificate. What is the certificate? This certificate, which is issued by Karnataka High Court, tells me that this particular case involves an interpretation of the Constitution. And when it involves interpretation of the Constitution, who is the final interpreter of the Constitution? The Supreme Court. Based on this certificate, which is provided by Karnataka High Court, I can file an appeal in the Supreme Court. This is a constitutional matter. What am I talking about? Appellate jurisdiction. You're not satisfied with the verdict of the High Court, you can file an appeal before the Supreme Court for your case. But this case can be of three types. It can be either a civil case, constitutional case, or a criminal case. Let's assume it is a constitutional case. If I lost this case in a Karnataka High Court, but Karnataka High Court issues a certificate. This certificate tells that this particular case involves the interpretation of the Constitution. And when I'm showing the certificate to the Supreme Court views the certificate and assumes that yes, Karnataka High Court is telling me to hear this case. That means you can file an appeal against the High Court judgment in the Supreme Court. That is what we call the constitutional matter when it comes to appellate jurisdiction. But this certificate is very important. High Court should provide the certificate. Based on the certificate, you can file an appeal before the Supreme Court. Now there is a civil matter. Let's say, for example, I approach Karnataka High Court, and this is a civil matter. What is a civil matter? We have discussed a dispute between two individuals, two sets of individuals, two groups for that matter. If I lost this case in Karnataka High Court, even then I can file an appeal before the Supreme Court, provided the High Court issues a certificate again. This certificate should mention two things. Number one, this particular case involves a substantial question of law, and this substantial question of law is of general importance. Let's say, for example, there is a civil case involving the divorce, and a case is filed in Karnataka High Court, and the petitioner loses this case. But even at the same time, Karnataka High Court issues a certificate and says that since it deals with divorce, but it's a very curious case, because in this case, both husband and the wife, for example, they don't want a divorce, but somehow the circumstances are such that divorce should be granted. Karnataka High Court issues a certificate saying that this particular case involves a substantial question of law, which is of general importance, and as such, this case can be heard in the Supreme Court. You can file an appeal before the Supreme Court based on this certificate. Second, the High Court may mention in the certificate that this case should be heard by the Supreme Court. That means High Court itself is saying, yes, we have dismissed your petition, but this case can be heard in the Supreme Court as well. Based on this certificate, I can file a case before the Supreme Court. Originally, there was a requirement that if there is a civil case which involves 20,000 rupees, that means the dispute is over 20,000 or more sum of rupees, then only such cases can be filed on an appeal before the Supreme Court. If it is less than 20,000, then the case will die at the High Court level. But in the year 1972, this 20,000 requirement was done away with. Now any set of case can be filed in the Supreme Court, provided the certificate is issued by the High Court involving two things. One, the High Court can say in the certificate that this particular case involves a substantial question of law which is of general importance, and as such, Supreme Court can hear this. Second, the Supreme Court should hear this case. This should be mentioned in the certificate, and then you can file an appeal before the Supreme Court. This is a civil matter. Now there can also be a criminal matter. How? Let's say, for example, I am accused in a murder case. District Court said, no, you are not guilty, set him free. Then the police or the state filed an appeal before the High Court. High Court said, no, I am guilty and I should be sentenced to death. In such a matter, I can file an appeal before the Supreme Court, and it is my right. That means in this case, I don't need a certificate from the High Court. Even in absence of a certificate, I can file an appeal before the Supreme Court, because in this case, it is my right. Because the District Court said me free. High Court is pronouncing me guilty and sentencing me to death. In such a case, I can file an appeal before the Supreme Court, and it is my right. There is another instance. District Court was hearing my case, but High Court came into the picture. High Court said, I am transferring this case from a District Court to High Court. I will hear this case, and High Court has now sentenced me to death. That means there was a case being heard by the District Court. High Court entered into the picture and said, no, I'm shifting this case from District Court to High Court. Now I'm hearing this case, and after hearing this case, the accused is guilty, and let's sentence him till death. In such a case, I can file an appeal before the Supreme Court, and it is my right. That means I don't need any certificate from the High Court. Even in absence of the certificate from the High Court, I can file an appeal before the Supreme Court, because it is a matter of death sentence. And in these matters, it is my right to file an appeal before the Supreme Court. Supreme Court cannot ask me, where is the certificate from the High Court? Even in absence of the certificate, I can file an appeal before the Supreme Court. There can be third instance as well. High Court itself can say, in the form of a certificate, that this case is fit to be heard by the Supreme Court. In such a case, when the certificate is presented to me, I show the certificate to the Supreme Court registry, and ultimately I can file an appeal before the Supreme Court. These are the three types of matters: civil, constitutional, and criminal. Wherein on these matters you can file an appeal before the Supreme Court. But there has been a change in the criminal appellate jurisdiction of the Supreme Court in the year 1970. What is that change? If, for example, District Court set me free, but High Court on an appeal sentenced me to life imprisonment or 10 years, I can file an appeal before the Supreme Court. Initially I was set free, but High Court sentenced me to death. I can file an appeal before the Supreme Court. After 1970, things have changed. I was set free by the District Court, but the state filed an appeal before the High Court. The High Court sentenced me to life imprisonment or a term of 10 or more years. In this case also, I can file an appeal before the Supreme Court. Second instance, District Court was hearing my case. High Court entered into the picture, took the case onto itself, and sentenced me to life imprisonment or a term of 10 or more years. Even in this matter, I can file an appeal before the Supreme Court. That is what we call appellate jurisdiction. These are the things that are primarily relevant for your prelims examination. Original jurisdiction, what are the exceptions? Appellate jurisdiction, what are the various provisions of appellate jurisdiction? Now let's look at special leave petition, which comes under Article 136 of the Indian Constitution. I told you that in a civil case, in a constitutional case, in some of the criminal cases as well, a certificate should be issued by the High Court, and when this certificate is issued, based on this certificate, you can file an appeal before the Supreme Court. What if the High Court refuses to grant you the certificate? You can still approach the Supreme Court under special leave petition, under Article 136 of the Indian Constitution. That means even in absence of the certificate issued by the High Court, a special leave petition can be filed in the Supreme Court under Article 136 of the Indian Constitution. But you cannot file a special leave petition against the order of a court martial. That means what is a special leave petition? It is not the extraordinary tools available to the Supreme Court, but this is a discretion of the Supreme Court. This special leave is not the right of an individual. That means I cannot approach the Supreme Court as a matter of right and ask the Supreme Court, please issue a special leave petition so that I can file this case before the Supreme Court. It is a discretion of the Supreme Court. And at the same time, this special leave petition can be filed in all cases, whether it's a civil case, criminal case, or a constitutional case. This special leave petition can be filed against any body. That means against any institution, whether it is High Court, whether it is any tribunal, except the court martial tribunal. That means if a court martial tribunal has sentenced me to dismissal, in absence of the certificate, I cannot file an appeal before the Supreme Court. This certificate is necessary. That means if there is no certificate, I cannot use the route of special leave petition under Article 136 of the Indian Constitution. There's another jurisdiction of the Supreme Court called writ jurisdiction of the Supreme Court. And this is something that we have discussed in the chapter Fundamental Rights, wherein we talked about if fundamental rights are violated, then various types of writs can be issued by the Supreme Court and your fundamental rights can be protected. For example, the writs of habeas corpus, mandamus, certiorari, prohibition, quo warranto. That is another jurisdiction or power of the Supreme Court, writ jurisdiction. Now let's look at advisory jurisdiction. Under Article 143 of the Indian Constitution, Supreme Court acts as the advisor of the President of India. That means President can refer any matter to the Supreme Court asking the views of the Supreme Court on this matter. That means any matter can be referred by the President to the Supreme Court asking the views of the Supreme Court on this matter. But this matter can be of two types. Either it can be pre-constitutional or it can be post-constitutional. What are we talking about? Under Article 143, which is a unique power available to the President of India, Supreme Court acts as the advisor of the President of India. President can refer a matter to the Supreme Court asking the views of the Supreme Court on this matter. But this matter can be related to pre-constitutional time, that means prior to 1950, or this matter can be after the commencement of the Constitution, which is after 1950. Clear? If it's a pre-constitutional matter, it is binding on the Supreme Court to give an advice to the President. That means if an advice on a pre-constitutional matter is sought by the President of India from the Supreme Court, it is binding on the Supreme Court to give an advice to the President. But if it is a post-constitutional matter and an advice is sought by the President on this post-constitutional matter, then the Supreme Court may or may not give an advice on this matter. Clear? But it is an advisory jurisdiction. Whatever advice is given by the Supreme Court, is it binding on the President of India on the face of it? No. Because it is only an advice. An advice is not binding on the President, but for all practical purposes, it is binding. How? Let me give you an example. If it's a pre-constitutional matter and an advice is sought by the President on this pre-constitutional matter, it is binding on the Supreme Court to give an advice. But various Supreme Court rulings have said that if Supreme Court will say, on this matter, I have no advice to give, even this statement can be treated as an advice. What does that mean? That means on a pre-constitutional matter, the President is asking the Supreme Court, please give advice on this matter. Supreme Court can say, on this matter, I have no advice to give. Even this can be treated that an advice has been given by the Supreme Court, and this advice is, I have no advice to give. Clear? But if it's a post-constitutional matter, it is not mandatory on part of the Supreme Court to advise the President. Supreme Court may or may not give advice to the President. We have seen Hindu court bills. That was a presidential reference given by the center, given by the President to the Supreme Court, asking the views of the Supreme Court on this matter. We have just recently discussed appointment of judges. A presidential reference was sent by the President to the Supreme Court in 1998, asking the views of the Supreme Court on that matter. We saw when 122 2G licenses were cancelled by the Supreme Court. When Dr. Manmohan Singh was the Prime Minister, spectrum was allocated to various private players, and this spectrum was allocated on the basis of first come, first serve basis. Okay? And based on this first come, first serve basis policy, 122 2G licenses were issued to the private players. CAG said this policy is flawed, and it has led to the loss of 1,76,000 crore to public exchequer. Matter went to the Supreme Court. Supreme Court said first come, first serve basis is a flawed policy, and since there is an element of corruption involved, 122 2G licenses stand cancelled. Then the President was asked by the government, please send a presidential reference to the Supreme Court and ask the views of the Supreme Court on this matter. That basically, how can we then sell the spectrum? How can we allocate spectrum, which is a very important resource? Supreme Court accepted this presidential reference, gave an advice to the President that when it comes to first come, first serve basis, you should not sell spectrum on the basis of first come, first serve basis. You should sell spectrum on the basis of an auction. That means spectrum is a very important resource, and we should maximize the revenue from this resource, and we should auction this resource. We should not follow first come, first serve basis. This was the advice given by the Supreme Court on this presidential reference. Now, when I say this presidential reference or the advice given by the Supreme Court is not binding on the government, on paper it is not binding on the government, but in practice it is effectively binding on the government. What if tomorrow the government would not have used the auction route, but would have still followed first come, first serve basis? Matter would have again been presented before the Supreme Court, and Supreme Court would have said this policy is null and void. That means for all practical purposes, this advice is binding on the government. But if there is a prelims-based question asked in your examination, then you can say, since it is advisory jurisdiction, it is not binding on the government. Clear? Let's look at the last jurisdiction, which is advisory jurisdiction. What is advisory jurisdiction? The Supreme Court can revise its own order. The Supreme Court can revise its earlier judgment. That means the judgment given by the Supreme Court is binding on everybody, is binding on all sections of the society except itself. That means the judgment given by the Supreme Court is not binding on itself in a manner that Supreme Court can revise it. That means, let's say for example, Section 377. Delhi High Court said Section 377 is unconstitutional. Supreme Court said no, Section 377 is constitutional. Then an appeal was filed against the Supreme Court in the Supreme Court against the same Supreme Court's verdict. Supreme Court said Section 377 is constitutional. When Supreme Court said, does it mean that this is the final verdict now? Nothing else can happen? No, advisory jurisdiction. File an appeal in the Supreme Court against the Supreme Court judgment itself, and that is what we call a review petition. Dear Supreme Court, please review your original judgment. And even if this review petition is dismissed, even then you can file another review petition, and this time the second review petition is called curative petition. This is one of the most beautiful, striking landmark judgments of the Supreme Court in this country. How? Supreme Court said in the year 2002 in Rupa Ashok Hura versus Ashok Hura. Supreme Court said although finality of a judgment is very important, because a case may have traveled from district court to high court then to Supreme Court. Then even in Supreme Court a review petition is filed. Clear? That means certainty, at least at some point in time the case should become dead. At least at a certain point in time the judgment should become final. Supreme Court in this 2002 judgment said although certainty of the judgment or finality of judgment is very important, but this cannot be at the cost of justice. That means even after your review petition is dismissed, you can file another review petition, and this time this review petition is called curative petition. Clear? But there are some very important grounds on the basis of which this curative petition can be filed. This curative petition can be filed if, number one, the judgment of the Supreme Court has adversely affected the individual. In this case, you can file a curative petition. When can a judgment adversely affect an individual? If it is the death sentence. In death sentence cases, you can file a curative petition. Second, if principles of natural justice have been violated. How? When my review petition was being heard, my side of the story was not heard. That means the judgment was given ex parte. That means the judgment was given without hearing the other side. If this has happened, you can file a curative petition. Third, if the judges or a judge who heard this case, who heard my case, he could not disclose his close links with the petitioner. That means if my case was against an individual or a company A, the judge who heard my case is a relative of A or is closely associated with A, and this he was not in a position to disclose when he heard my case. That means there may have been an element of bias when the judge gave this judgment. On these limited matters, you can file a curative petition. That means when my review petition is dismissed, then I can file a curative petition on these grounds. When I file this curative petition, then this curative petition will be given to 3 senior most judges of the Supreme Court plus those judges who heard this case in the first place. And when the majority of these judges decide that yes, this case should be heard again, your curative petition will be accepted and this case will be heard again. Otherwise, your curative petition will be rejected, then you don't have any other legal option but to approach the President of India with the mercy petition. What are we talking about? The various jurisdictions of the Supreme Court. One is original jurisdiction and some exceptions. Appellate jurisdiction, civil, criminal, constitutional. Then we talked about writ jurisdiction. Then we talked about advisory jurisdiction. Now we are talking about revisory jurisdiction. That means even if Supreme Court has dismissed your petition, you can file an appeal before the same Supreme Court. That is what we call a review petition. Even if this review petition is dismissed, you can file another review petition, and this time this review petition is called curative petition. And when did this concept of curative petition originate? In the year 2002 in Hura versus Hura, wherein Supreme Court said, although finality of justice is very important, but it cannot be at the cost of the justice. Finality of a verdict is very important, but it cannot be at the cost of the justice. And you can file curative petition, but on very limited grounds. Which are these grounds? These are the grounds. And if these grounds are accepted, then this curative petition is forwarded to three senior most judges of the Supreme Court, as well as those judges who heard this case in the first place. And if the majority of these judges decide, yes, this case should be heard again, then ultimately this curative petition will be heard. But in India, the success ratio of this curative petition is very, very poor, because only very limited grounds this curative petition is filed. That is what you need to know regarding the jurisdiction of the Supreme Court. Now let's look at how the judges of the Supreme Court and High Court can be removed from their offices. We know that the tenure of a judge of a Supreme Court is still 65 years. The tenure of a High Court judge is still 62 years. But before completing this term, there can arise a vacancy. Vacancy can be the judge of a Supreme Court can resign from his office. The judge of a High Court can resign from his office. But there can also arise a vacancy if the judges of a High Court or Supreme Court are to be removed from their office. How? The judges of the High Court and the Supreme Court can be removed from their offices on the grounds of crude misbehavior or incapacity. Misbehavior is a very vague term, so it can be corruption, it can be sexual harassment, it can be anything. Incapacity, maybe you're not performing that well to merit a seat at the Supreme Court or the High Court. But both these charges of misbehavior or incapacity shall have to be proved. How? For that there is a process. The judges are appointed by President. The judges are removed by the President as well. But the President cannot remove the judge of a Supreme Court or High Court on his own. The President has to follow on the basis of the resolution passed by both houses of the Parliament, and that too by special majority. Let's look at what is the process. But first things first, number one, the judges, they have a specific tenure till they attain a specific age, but before that they can be removed from their offices. On what grounds? On the charges of misbehavior or incapacity, but these charges should be proved. How can these charges be proved? Let's look at the procedure. Let's say, for example, there is a Judge A. This Judge A is to be removed from his office. Who can initiate this process? This process can be initiated in either. There's a Judge A. This Judge A is to be removed from his office. Who can initiate this process? This process can be initiated in either Lok Sabha or Rajya Sabha. In either of the two houses, let's assume Lok Sabha members decide to remove this Judge A. For that, 100 members of Lok Sabha should sign a memorandum, should sign a motion, and present this motion to the Speaker of Lok Sabha that this Judge A should be removed from his office. Or if this process is initiated in Rajya Sabha, then what is the requirement? 50 MPs of Rajya Sabha should sign a motion and present this motion to the chairperson of Rajya Sabha that this Judge A should be removed from his office. Clear? Let's understand this in great detail. Let's assume that this process is initiated in Lok Sabha. Lok Sabha 100 members, they write to the Speaker that this Judge A should be removed from his office. Initiate the proceedings so that this judge is removed from his office. When Speaker is presented this motion, Speaker may or may not accept this proposal. Speaker may or may not accept this motion. For example, when Justice Deepak Misra is the first Chief Justice of India against whom removal motion was introduced in Rajya Sabha, more than 50 members of Rajya Sabha, they presented a proposal before the chairperson of Rajya Sabha, who is the Vice President of India, that Chief Justice of India, Justice Deepak Misra, should be removed from his office on the charges of misbehavior and incapacity. But this time, the chairperson of Rajya Sabha, Venkaiah Naidu, rejected this motion. The Speaker said, the chairperson said, I'm not going to consider this proposal. That means it is the discretion of the presiding officer. It is the discretion of the Speaker or the chairperson whether to accept this proposal or not, whether to accept this motion or not, whether to accept this request or not. If, for example, the Speaker of the Lok Sabha accepts this proposal by 100 members of the Lok Sabha, then what Speaker has to do? Speaker has to constitute a committee. And this committee shall consist of 3 members. Who is the member of this committee? Number 1, Chief Justice of India or a judge nominated by Chief Justice of India. Number 2, Chief Justice of a High Court or any High Court judge nominated. Third, a distinguished jurist. That means these are the 3 members who are nominated to this committee, and this committee is constituted by the Speaker or the chairperson wherever the proposal is pending. And now this committee will have to prove these charges, will have to investigate these charges, whether the allegations of misbehavior or incapacity against this judge are correct or incorrect. And then the committee submits this report, and after this report is submitted, then voting takes place in Lok Sabha. If this motion is passed by special majority, then this motion is passed by Lok Sabha. This motion is then sent to Rajya Sabha. In Rajya Sabha also, if this resolution is passed by special majority, then ultimately what happens? This resolution is sent to the President, and the President will have to, he has no other option but to sign this resolution, and then this judge is removed from his office. What are we talking about? The removal process of the judge of the Supreme Court and High Court. Because the appointment process of both High Court judge and Supreme Court judge is the same, the removal process of the High Court judge and the Supreme Court judge is also the same. What is the removal process? I am the judge of a High Court or Supreme Court. I am to be removed from my office. Who can remove me from my office? The President of India. Because President is the appointing authority, President is the removal authority as well. But President cannot remove me on his own. President has to remove me only on the basis of the resolution passed by both houses of the Parliament, that too by special majority. But for that, there is a procedure that is to follow. And this procedure is mentioned under Judges Inquiry Act of 1968. According to this Judges Inquiry Act of 1968, if a judge of a High Court or Supreme Court is to be removed, this process can initiate in either Lok Sabha or Rajya Sabha. In Lok Sabha, 100 members signature is required. In Rajya Sabha, 50 members signature is required. Let's say we're talking about Rajya Sabha. 50 members sign the petition that a judge A should be removed. This petition is given to the Speaker, to the chairperson of Rajya Sabha. Chairperson may or may not accept this proposal. If he accepts this proposal, then he sets up a committee. This committee consists of 3 members. 1, Chief Justice of India or a judge nominated by Chief Justice of India. Chief Justice of a High Court, or a judge nominated and a distinguished jurist. Now, this committee will submit a report, will now investigate, inquire into these allegations of misbehavior and incapacity, and then this committee submits a report. But is this report binding on the Parliament, binding on the Lok Sabha and Rajya Sabha? Yes, as well as no. How yes and no? If this committee says that the allegations of misbehavior and incapacity against this Judge A are false, these allegations have not been proven, all these allegations are preposterous, false, inaccurate, then the Parliament cannot proceed and cannot vote on this proposal. That means the proceedings against the judge will stop then and there. That means this report of the committee is binding in one case, and that case is if the committee says no action should be taken against the judge because these allegations have proven to be false, then the Parliament cannot initiate the removal process, cannot continue with the removal process. But if this committee says, yes, the allegations against this judge have been proven, yes, the judge is indeed accused of misbehavior and incapacity, and this accusation is true, then you can proceed and go ahead with the removal of the judge of the High Court or Supreme Court. But in this case, it is not binding on the Parliament. Parliament may not persist with the removal, because after all, it depends upon whether in Lok Sabha, 2/3 majority is there in favor of the removal or not. Whether in Rajya Sabha, special majority favors the removal of this judge or not. That means the committee's report, is it binding on the Parliament or not? It is binding in one case. And what is this case? If the committee says don't persist, don't go ahead with the removal because the allegations are false, then the Parliament cannot initiate, cannot continue with this resolution. But if this committee says the allegations are true, correct, you can go ahead and remove this judge. Parliament may or may not continue, Parliament may or may not insist upon the removal of the judge. But if both houses of the Parliament pass this resolution by special majority, and then in the same session, this resolution is sent to the President, then the President will sign and the judge will be removed from his office. What is the same session? That means if, for example, today is the budget session of Indian Parliament. In this budget session of Indian Parliament, both houses of the Indian Parliament passed a resolution by special majority that a judge A should be removed from his office. In the same budget session, this resolution should be sent to the President for his signature. But at the same time, when this resolution is sent to the President for signature, he has no other option but to sign on this resolution, and the judges of the High Court or the Supreme Court can be removed from their offices. But such is the complex nature of the removal process that till date, no judge of the Supreme Court or High Court has ever been removed. There was first instance of Justice B. Ramaswamy. He was the judge of the Supreme Court, but when he was the judge or the Chief Justice of Punjab and Haryana High Court, there was some allegation of corruption against Justice Ramaswamy. When he was promoted to the Supreme Court, then removal proceedings were initiated against Justice B. Ramaswamy, but therein the Congress party abstained from the voting, they did not vote, and ultimately special majority could not be achieved. Justice B. Ramaswamy could not be removed from his office. Then was Justice Sumitra Sen, the judge of Calcutta High Court. There was an allegation against him as well. The special majority was acquired by Rajya Sabha. Then this resolution was to be sent to Lok Sabha, but then Justice Sumitra Sen thought that I would become the first person in the history of independent India to be removed on the basis of the resolution passed by the Parliament. So what he did, he resigned. Then we also saw removal proceedings were initiated against the Chief Justice of India, Justice Deepak Misra. When opposition political parties, spearheaded by the Congress, they decided that we should start a removal process against Chief Justice of India. Ultimately, the chairperson of Rajya Sabha did not accept it, and no removal proceedings could carry forward against Justice Deepak Misra. This is how the judge of a High Court or the Supreme Court can be removed from their offices. But two important things. Number one, we do not call this removal process impeachment. Although newspapers, magazines, various other coaching institutes would say that a judge is to be impeached. But we don't, from a legal point of view, call this process impeachment. We only call it removal. And number two, impeachment motion or a removal motion against the judge of a High Court or the Supreme Court, it does not lapse upon the dissolution of Lok Sabha. That means we have discussed in legislature that there are certain bills which lapse upon the dissolution of Lok Sabha. But if there is a removal motion against the judge, calling for the removal of the judge of a High Court or a Supreme Court, even if the Lok Sabha is dissolved, then this particular motion does not lapse upon the dissolution of Lok Sabha. That is what you need to understand about how the judges of High Court and Supreme Court can be removed from their offices. Now let me tell you two or three very quick points. Number one, acting Chief Justice of India. When the office of Chief Justice of India is vacant, or when the Chief Justice of India is unable to perform the duties of his office, then the duties of the office shall be performed by whom? Shall be performed by such of the other judges of the Supreme Court as the President may appoint for the purpose. Presidents, the office of Chief Justice is vacant, or Chief Justice is unable to perform the duties of the office of the Chief Justice of India. Then who will act as the Chief Justice of India? Somebody appointed by the President for this purpose. And this individual is known as acting Chief Justice of India. Second, ad hoc judges. Let's say, for example, there is a case to be heard, a constitutional case. To hear a constitutional case, the number of judges should be 5 or more. That is what we call Constitution Bench of the Supreme Court. If the Supreme Court has to hear a matter which deals with the interpretation of the Constitution, for that a Constitution Bench should be set up, and the number of judges on this Constitution Bench should be 5 or more. But let's say the Supreme Court has to hear an appeal to the Keshavananda Bharti judgment. This Keshavananda Bharti judgment was heard by 13 judges. Now, if we have to review this judgment, if we have to review the Keshavananda Bharti judgment, we need judges more than 13. Let's say we need 15 judges. But today in Supreme Court, for example, let's assume there are not 15 judges in the Supreme Court. So that means there is absence of a quorum. We need 15 judges to hear a particular case, but we only have 13 judges right now. For example, hypothetical situation. In this case, the Chief Justice of India, with the previous consent of the President of India, after the consultation with the Chief Justice of a High Court, what he can do? He can request in writing the attendance at the court of an ad hoc judge. What are we talking about? Right now, a particular case is to be heard. 15 judges are required. But we only have 13 judges right now in the Supreme Court. That means there's an absence of quorum. We need 2 more judges. Where will these 2 judges come from? Chief Justice of India will write to the President, that dear President, we need 2 judges from Calcutta High Court. So that these 2 judges from Calcutta High Court, although they are not judges of the Supreme Court, but these 2 judges of Calcutta High Court should be appointed to the Supreme Court on ad hoc basis. Primarily to look at this case, to hear this case. And Chief Justice has to consult the Chief Justice of Calcutta High Court as well. After his permission, 2 judges from Calcutta High Court will hear this case, Keshavananda Bharti judgment review in Supreme Court. This is what we call ad hoc judge. But one important difference. This is an ad hoc judge. That means this judge of a High Court is now an ad hoc judge of a Supreme Court for one specific purpose, to hear this case. After this case is over, this judge will go back to the Calcutta High Court. That means one important thing. The Constitution makes no provision for the appointment of temporary judges or acting judges of the Supreme Court. There can be an acting Chief Justice of the Supreme Court, but there can be no acting or temporary judges for the Supreme Court. Instead, the system of appointing ad hoc judges have been adopted for the Supreme Court. That's another important concept, can be relevant for your prelims. Now let's look at Article 128. What about the retired judges of the Supreme Court and the High Court? These retired judges of the Supreme Court and High Court can be asked to be present at the sittings of the Supreme Court. How? I'm the Chief Justice of India. I need a retired judge of a High Court or a Supreme Court to be present in the Supreme Court to hear a particular case. I will seek the permission of the President of India, and I will ask this retired judge to please come to the Supreme Court and hear this case. But it is not binding on the High Court judge, it is not binding on this retired judge that he has to accept my proposal. He may refuse, he may say, I'm not going to come and be present at the sittings of the Supreme Court. But there is a provision which can be relevant for your prelims examination. There is a provision under Article 128 where the Supreme Court Chief Justice, with the previous consent of the President of India, would ask a retired judge to be present at the sittings of the Supreme Court. But it is not binding. There can be no compulsion on the retired judges to accept this invitation. But now let's look at a very important article, Article 130 of the Indian Constitution, the seat of the Supreme Court. What is the seat of the Supreme Court? We have a Supreme Court at New Delhi. Constitution says the Supreme Court shall sit in Delhi or in such other place or places. That means it can sit at multiple places as well. The seat of the Supreme Court is in Delhi, or in such other place or places as the Chief Justice of India may, with the approval of the President from time to time, appoint. But as of now, we have a seat of the Supreme Court only in New Delhi. But there are various reports which suggest that what about people in South India? What about people in Northeast India? What about the people in Deep East India? If they have to approach the Supreme Court, this huge distance between their parent state and the Supreme Court, it discourages people from accessing justice. How? I'm from Tamil Nadu. I lost a case in the district court. I filed an appeal before the High Court. I lost the case in High Court as well. Now I can file an appeal before the Supreme Court of this country. Now when I'm calculating the costs, I come to a conclusion that number one, look at the distance between Tamil Nadu and Delhi. It will cost me a lot for travel, for boarding, for lodging, for food. I won't approach the Supreme Court. I will just give up. Is it not denial of justice? Even if I have money, but they say that more often than not, that the advocate who helped me in the High Court, I have to continue with his services in the Supreme Court as well. So I have to bring this lawyer from my High Court to Supreme Court. And in Supreme Court, I have to get a Supreme Court lawyer as well. So that this lawyer of my High Court can assist the Supreme Court lawyer at the Supreme Court. Boarding, lodging, travel expenses for this High Court lawyer or an advocate, it's going to cost me a lot. I'm not going to appeal before the Supreme Court. Is it not denial of justice? Now let's look at something else. In the year 2000, the Civil Procedure Code was amended. What is the impact of this amendment? If I was filing a case in the High Court and I lost this case in the High Court, then I could file an appeal before the division bench of the same High Court. That means I filed a case in the High Court. There one judge of this High Court. It was a single member judge. This High Court judge said, you have lost this case, we are dismissing your case. I could have filed an appeal against this judgment in the division bench of the same High Court, where now two judges will hear this case. But in the year 2000, Civil Procedure Code was amended, and because of this amendment, the amendment said, now bulk of the cases will not go to the division bench of the High Court, but will go to the Supreme Court. That means if you lost a case in the High Court, now you don't have an option of filing an appeal in the division bench of the same High Court. Now what is the only option available for you? Approach the Supreme Court. Now more and more cases are liable to be filed in the Supreme Court. It will be denial of justice for them. That is why many people argued, many advocates, many lawyers, state governments as well, Parliamentary Committee on Law and Justice as well, what they recommended, that we should have a Supreme Court in Delhi, yes, but at the same time, we should have regional benches as well. So we should have a regional bench in South India, we should have a regional bench in East India, we should have a regional bench in West India, we should have a regional bench in North India as well. That means we should have a Supreme Court in Delhi, but we should have regional benches in Northern, Southern, Eastern and Western India as well. That is how a citizen from South India, instead of going to Delhi, can file a case in a regional bench in South India, which can be in Chennai, which can be in Bangalore, which can be in Hyderabad. But at least it will be very closer to people in South India. But then the Supreme Court rejected this. Supreme Court rejected this on two grounds. Ground number one, it will affect the status of the Supreme Court as an institution of national importance. Something very vague term. How is it that constructing regional benches in Southern, Northern, Eastern and Western India would affect the status of Supreme Court as an institution of national importance? What sort of logic is that? We don't understand. So this is something which is very vague. It will affect our status as institute of national importance. I don't agree. I don't get it. Second, Supreme Court rejected this idea of regional benches on the ground that if regional benches are constituted, then local politics would affect them. That means these regional benches, if we are constituting, then these regional benches will be affected by the local politics. Then local political parties would influence these regional benches. That is why we should not set up regional benches. What do you think? Is it a plausible argument? Is it a justifiable argument? No. If regional benches would come under the influence of the local politics, then by the same logic, there should be no High Court in this country. Because then High Court of Tamil Nadu can come under the influence of local politics. Karnataka High Court, Calcutta High Court, Bombay High Court, all these High Courts should be dissolved because they can come under the influence of the local politics. So this is a very trite argument of the Supreme Court. I don't know why Supreme Court does not want to set up regional benches in different parts of this country. But at the same time, even if at face value, we take this argument seriously, that local benches or regional benches of the Supreme Court can come under the influence of the local politics, then at that time, you can transfer this case to another bench. You can transfer this case to another regional bench. For example, when a case was filed against the then Tamil Nadu Chief Minister J. Jayalalitha in a disproportionate assets case, many people allege that the Tamil Nadu court is coming under the influence of J. Jayalalitha. Then in that case, what happened? The Supreme Court of this country shifted this case, transferred this case to Karnataka High Court. Similarly, when Gujarat rights cases were heard by the Gujarat High Court, there was an allegation of interference by the state government, and ultimately what Supreme Court did, some of these cases were transferred from Gujarat High Court to Maharashtra High Court, Bombay High Court. That means there is always an option wherein you can shift the case from one High Court to another High Court if there is a political interference. In the same manner, let's have regional benches in different parts of this country, and if there is a regional bench which comes under the influence of local politics, we can shift that case from one regional bench to another regional bench. As simple as that. This is what we need to understand regarding Article 130 of the Constitution of India. But at the same time, Justice K.G. Balakrishnan, who was also the Chief Justice of India at one point in time, then was the head of National Human Rights Commission as well, Justice K.G. Balakrishnan made a very innovative solution, presented a very innovative formula solution to solve this problem. What he said Supreme Court should be split into two. One would be Constitutional Court, and this Constitutional Court would be in Delhi. And the other would be Cassation Court. And this Cassation Court will be in North India, South India, East India, West India, can possibly be in Central India as well. What are we talking about? If you look at Supreme Court, there are normally two broad types of cases that are filed. Some cases are constitutional in nature, others are appeals. What are these constitutional cases? These constitutional cases can be federal cases as well. For example, dispute between the central government and Arvind Kejriwal government in Delhi. Federal in nature. Dispute between Puducherry government and the Lieutenant Governor Kiran Bedi of Puducherry. Federal in character. Such cases should be filed in this constitutional court in Delhi. Also, if there is a case which involves interpretation of the constitution, a case which involves constitutional legalities, constitutional technicalities, such cases should be heard in this constitutional court which is in Delhi. But there are bulk of cases filed in the Supreme Court which are basically appeals. You did not agree with the High Court verdict, file an appeal against this High Court verdict in the Supreme Court. And bulk of the cases in the Supreme Court are of this kind, appeals. For such appeals, there is no need to go to Delhi. Create 4 or 5 cassation courts in Northern, Southern, Eastern, Western and possibly in Central India as well, so that these cassation courts can hear the appeals filed against the High Court judgments. That is how we can lessen the burden on the Supreme Court in Delhi, so that the Supreme Court in Delhi can focus on federal cases and constitutional cases. This is something that you can write in your answers when a question on Supreme Court's organizational reform is asked in the examination. One more thing. What is court of record? To satisfy that a particular institution is a court of record, two things should be satisfied. Two requirements should be satisfied. Number one, the judgments, proceedings and acts of the Supreme Court, they are recorded for perpetual memory and testimony. These records cannot be questioned when produced before any court. Supreme Court is a court of record because of two reasons. Reason number one, whenever a Supreme Court order is given, whenever a Supreme Court judgment is given, when this judgment is presented before any other institution, whether it is High Court, tribunal, any other institution, nobody can question this verdict of the Supreme Court. That means this verdict is treated as a valuable document, as a legitimate document. That is why Supreme Court is a court of record. And at the same time, the Supreme Court has the power to punish for its contempt. And in Article 19 of the Indian Constitution, when we discuss freedom of speech and expression, we discuss contempt of court as well. So Supreme Court has the power to punish people for its contempt. Number one. Number two, its records, judgments, documents are treated for perpetual memory and testimony, and these records can not be questioned when produced before any court. That is why Supreme Court is a court of record. Which other institution is a court of record? High Court. Because High Court can also punish people for its content, and High Court's judgments, proceedings, and acts are also recorded for perpetual memory and testimony. But what about district courts? District courts' records are also treated as valuable documents, which are used for perpetual memory and testimony. But district courts do not have the power to punish people for its content. But does that mean if you scandalize a district court, no action can be taken against you? Yes. But this time, the action can be taken by a High Court on behalf of the district court. Confusing? Let me make it simple for you. We say that there are some institutions which are declared as courts of record or court of record. Which are these institutions? Any institution can be declared as a court of record if it satisfies two conditions. Condition number one: if this institution's orders, judgments, acts are treated as valuable documents, are recorded for posterity, are recorded for future testimony, are recorded for future reference, for perpetual memory. And second, if this institution has the power to punish those who commit a contempt of this institution. And in this condition, there are two institutions which can be referred to as court of record: High Court and Supreme Court. But what about district court? District court cannot punish people for its content. But if you scandalize a district court, if you say that a district court judge is a thief, is a corrupt, has been giving these judgments because he has been paid money by different sections of the society, then does that mean no action can be taken against you? Yes, action can be taken against you, but not by the district court, but by High Court. That means High Court can punish people who commit contempt of a district court. District court itself on its own cannot punish people for the content. That is what is called court of record. Now let us discuss public interest litigation. We will talk about the concept of public interest litigation and the origin of this concept. We'll talk about the rules, the purposes, criticism, and the new rules surrounding public interest litigation. But first up, let's understand the power of judicial review. Now if you look at judicial review, what does that mean? Executive has the power, has the authority, has the responsibility of making rules, making regulations, so on and so forth. Policy making is the domain of the executive. That's something the power of the executive. What is the job of the legislature? The job of the legislature is primarily to make laws. That means when we look at executive and judiciary and legislature, these are the three important organs of the state, and the responsibility for all these three organs is clear-cut mentioned in the Constitution. Executive has to deal with making policies, rules, regulations, programs, so on and so forth. The job of the legislature is to make laws. This is where the concept of judicial review enters into the picture. What is judicial review? Judiciary will review what? Rules, regulations, and policy making of the government. Similarly, the laws passed by the parliament. That is the power that judiciary has, judicial review. But if you look at this concept of judicial review, it is not mentioned anywhere in the Constitution. Constitution does not mention that judiciary has the power to review the laws passed by the parliament. Judiciary has the power to review the policies, programs, rules, and regulations of the executive. It is not explicitly mentioned anywhere in the Constitution. Then how can we draw this inference that judicial review is one of the most important powers of the judiciary? We can draw the inference. That means the traces of judicial review can be seen under Article 13 of Indian Constitution. When Article 13 Clause 2 says that Parliament cannot by law abridge a fundamental right or snatch a fundamental right, because that is not the power available with the Parliament. That is not the power available with the legislature. If Parliament abridges a fundamental right by passing a law, snatches a fundamental right by passing a law, then judiciary will enter into the picture and declare that law unconstitutional. Although it is not mentioned, but since Article 13 Clause 2 says that Parliament does not have this power, and at the same time, the Supreme Court is the guardian of the Constitution, the protector of the fundamental rights, the judiciary will enter into the picture and review that law. So we can trace the concept of judicial review, number one, in Article 13 of the Indian Constitution, as well as Article 32 of the Indian Constitution, which talks about right to constitutional remedies. If your fundamental rights are violated, you have an option: approach the judiciary. Judiciary is the protector of your fundamental rights. Supreme Court is the protector of your fundamental rights, and writs will be issued, which will guarantee you your fundamental rights back. So we can trace the concept of judicial review to Article 13 and Article 32 of the Indian Constitution. That is what we call judicial review. Then what is this? Public interest litigation. The origin of public interest litigation is social action litigation, which is found in United States of America. What is there in the United States of America? Social action litigation. And that is the concept of public interest litigation in this country. How? If some individuals, or if a group of individuals, or even if one individual takes up the cause of the public in larger public interest, that means if there is an individual who approaches the judiciary, not for himself, but for the larger public good, that means he is filing this case, or he is doing this pro bono publico. That is the maxim surrounding public interest litigation. That means there is an individual who is approaching the judiciary, filing a petition, not for himself, but for others. That means he is taking up this case pro bono publico in larger public interest. That is what we call public interest litigation. But in India, what is the origin of this public interest litigation? 1979. There was a lawyer, Kapila Hingorani. She became, in 2017, the first female lawyer whose portrait can be found in the library of the Supreme Court of this country. What is the contribution of Kapila Hingorani? In 1979, she was reading some newspapers and she found out the condition of under trials in Bihar. In Bihar jails. What was the condition of these under trials in Bihar jails? When she dig deeper, she realized that there are some under trials in Bihar jails. What are these under trials? For example, I am accused in a crime, in a murder, in dacoity, in theft, in rape, for example, under arms act, for example. Now I have been arrested by the police. I have not been convicted by the judiciary. That means the case is still continuing, but I'm still in the jail. When I'm in the jail, that means I'm under trial. I'm under trial. I'm accused as of now. I'm not guilty yet because there's a golden rule of criminal justice system. You are innocent until proven otherwise. That means I'm innocent right now. I'm under trial. I'm still not pronounced guilty by the judiciary in this country. Kapila Hingorani, when she dig deeper, she found out that there are under trials in Bihar jail who are serving more time in the jail than they would have served if they were pronounced guilty. What does that mean? Let's say, for example, I have been arrested under Arms Act, but I'm still under trial. That means court has not pronounced me guilty. The maximum punishment for those who are convicted under Arms Act, let's say it is 5 years. That means even if I'm convicted under Arms Act, maximum punishment that can be available to me is 5 years in a jail. But I, as an under trial, I have served 9 years in jail. What sort of logic is this? That means I have served more time in jail than I would have served if I was convicted. But right now I'm under trial. The case is continuing for close to a decade. If I would have been even convicted for 4 years, I should have been free. For 4 years, I should have been out of the jail. But since the case is still continuing at a snail's pace, I have been serving more time in the jail than I would have normally done if I was convicted. But on top of that, what if I was innocent? What if I was set free by the judiciary tomorrow saying you are not guilty, you are innocent? What will I do with these 9 beautiful youth years? What am I going to do? Kapila Hingorani, when she found out this, she filed an application, she filed a petition in the Supreme Court. Two judges of the Supreme Court, Justice B.R. Krishna Iyer and Justice P.N. Bhagwati. When they heard this plea from Kapila Hingorani, what Supreme Court said? Supreme Court said that 44,000 under trials in Bihar are to be released. That means based on this petition, Supreme Court ordered the release of 44,000 under trials because they have served more time in jail than they would have normally served if they were pronounced guilty. But do you know what is the most beautiful thing in this entire case? You might say this is normal. Somebody filed an application before the Supreme Court said, release these 44,000 people. This might sound normal in 2019, but it was not normal in 1979. Do you know why? Because no judge, neither Justice Bhagwati nor Justice V.R. Krishna Iyer, asked Kapila Hingorani, what is your locus standi? Beautiful concept. Because prior to 1979, if I'm an aggrieved individual, only I could have filed this case, or my relatives could have filed this case. In this case, Kapila Hingorani is not related to any of these 44,000 trials. The judges did not ask Kapila Hingorani, what is your locus standi? How are you connected with this case? How are you related with these 44,000 under trials? Without asking the question of locus standi, the court released 44,000 under trials. That means the beauty about public interest litigation is this locus standi concept does not apply. Any public-spirited individual can file a petition before the court for the larger public interest, and the court will dispense justice in this matter. That is what we call public interest litigation. Let me tell you something else. Sunil Batra, he was a prisoner in Tihar jail. What he did, he used a postcard, and he sent this postcard to Supreme Court. And in this postcard, Sunil Batra is explaining the inhuman treatment meted out to the prisoners at Tihar. And what Supreme Court did, Supreme Court ordered jail reforms in different jails in this country. Now you will say, what's the difference? In Kapila Hingorani case, Kapila Hingorani filed a petition before the Supreme Court. Based on this petition, the Supreme Court heard this matter and ordered the release of 44,000 under trials in Tihar. In this case, no petition has been filed. Supreme Court took even a postcard and said this postcard is like a petition. That means you don't have to file a formal petition so that your PIL can be heard. Even a postcard is sufficient. Even a postcard would suffice so that justice is delivered to the people of this country. That is public interest litigation. That means if I can tell you exactly what is this public interest litigation. Number one, an individual approaches the Supreme Court on behalf of public, on behalf of larger public, and files a petition. That means locus standi does not apply. That is what public interest litigation is. Second, you don't have to file a formal petition in the Supreme Court so that your PIL can be heard. Even a postcard is sufficient enough. Third, PIL is mostly filed when matters related to fundamental rights are concerned. That's a very important distinction when it comes to PIL and other matters. PIL specifically deals with fundamental rights. Number four, suo motu. What is the suo motu? On its own. Normally, when does Supreme Court take up a matter or judiciary take up a matter? When somebody approaches the judiciary, I approach the judiciary with a petition, someone else approaches the judiciary with a case, and then Supreme Court hears this matter or judiciary hears this matter. But so far as PIL is concerned, the Supreme Court or the High Court can act on its own, suo motu, without someone filing a case. To give you an example, people went on Amarnath Yatra, pilgrimage. The condition of the pilgrimage was pathetic, the road was treacherous, the terrain was very bad, medical facilities were not provided, and ultimately it led to the deaths of many Amarnath Yatra pilgrims. When this newspaper report came up, the judges took this newspaper report as a public interest litigation and on its own referred this matter to the government and asked the government that you have to take steps to provide better medical facilities and treatments to those who go on an Amarnath Yatra pilgrimage. That's another beauty about public interest litigation. In India, only a court of record has the power to accept public interest litigation. And which are the two courts of record in this country? Number one, it is the Supreme Court, and number two, it is the High Court. That is what public interest litigation is all about. But then what is the beauty about public interest litigation? What is the best thing about public interest litigation? What are the advantages of public interest litigation? Number one, if you look at Article 19 of Indian Constitution, Article 21 of the Indian Constitution, you will see a number of inferred rights. That means under Article 19 Constitution said freedom of speech and expression. But when this freedom of speech and expression is to be expanded, who expanded this freedom of speech and expression definition? Supreme Court. Supreme Court said right to information is a fundamental right under freedom of speech and expression. Right to make an informed choice is a fundamental right under freedom of speech and expression. All these candidates who are contesting election, they have to mention their criminal record. They have to mention their educational qualification. They have to mention the criminal cases pending against them. They have to mention the assets that they have in their name and in the name of their spouse. Why? So that this information can help the voters to make an informed choice. And it is this informed choice that is part of the freedom of speech and expression. All these things were based on public interest litigation filed by various organizations in the Supreme Court. Similarly, Article 21, we see environmental laws have been expanded very deeply, have been expanded very liberally by the judiciary, and it is all based on the public interest litigation filed by various individuals in the Supreme Court. So if you were to ask me, what is the significance of public interest litigation? Number one, the significance is that it is because of the power of the public interest litigation that various fundamental rights have been expanded, and those fundamental rights have been given to the people of this country which were not originally part of the Constitution. So when right to clean and clear environment is a fundamental right under Article 21, that was not mentioned under Article 21 originally. That was given to the people of this country because PIL was filed. Similarly, a right to make an informed choice. Similarly, freedom of press. All these have been made possible because of public interest litigation. That's number one. Number two, if you look at literacy, there are still large sections of the society which are not educated, which are not literate. But at the same time, if you look at judicial literacy, it is even more pathetic. Let me ask you a very honest question. Before you decided that I want to appear for the civil services examination, were you knowing what is a fundamental right? Were you knowing what are the powers available with the Election Commission of India? Were you knowing that what are the rights that you have as a citizen and what are the duties that you have as a citizen? That means if we look at judicial literacy in this country, it is very, very poor, pathetic. But on top of that, we have poor people in this country. Poor people, they lack judicial literacy. Even if they possess judicial literacy, but they don't have means to pay to their lawyers and then get access to the judiciary in this country, get justice from the judicial institutions in this country. It is here that various non-governmental organizations enter into picture, and they take the causes of sex workers, they take the cause of child laborers, they take the cause of street vendors, and it is because this concept of locus standi does not apply to a public interest litigation. This is where non-governmental organizations enter into picture, take up the causes of the poor, marginalized, disprivileged sections of the society, so that justice can be made available to this very important part and parcel of our population. That is the beauty of public interest litigation. But at the same time, there are some criticisms as well. What are these criticisms? Some people say that it is not public interest litigation, but it is personal interest litigation. Some people say it is not public interest litigation, but it is publicity interest litigation. Frivolous, vexatious public interest litigations have been filed in the Supreme Court. There was a PIL filed in the Supreme Court that dear Supreme Court, please declare that the name of this country is Bharat and not India. A PIL was filed in the Supreme Court asking the Supreme Court please take steps to bring back Kohinoor diamond from Britain. A PIL was filed to ban Sardar jokes in this country. A PIL was filed wherein the petitioner asked when will Achhe Din come. That means more and more frivolous, vexatious public interest litigations have been filed on irrelevant matters. And unfortunately, what happens because of this? You are choking our judicial system. There are already crores and crores of cases pending in our judiciary. And when you file these PILs, vexatious PILs, ridiculous PILs, you are choking our judicial system. That's one problem with public interest litigation. There is another problem. So far as these publicity interest litigations are concerned. For example, Dr. Subramanian Swamy filed a public interest litigation in the court asking for a fair investigation into the death of Sunanda Pushkar, the wife of Congress politician Dr. Shashi Tharoor. Now you may say this is a valid case. Clearly, yes. But what is the public interest that can be served by filing such a case? Public interest litigation, as the name suggests, it is for larger public interest. It is not for your personal interest. It is not for settling personal scores with each other. So you have to understand it very carefully. This is the problem with public interest litigation. But that does not mean the courts have not taken any steps to prevent these vexatious PILs from being filed, the courts have taken steps. For example, in Gujarat, there was a PIL filed in the Gujarat High Court asking for a ban on asbestos companies and factories in Gujarat. Why? Because it is polluting our environment. The court initially thought this is a very beautiful public interest litigation. It is for these purposes that you should come before the court and file these public interest litigations. But then in PIL matters, the courts normally appoint somebody called amicus curiae. What is amicus curiae? Amicus curiae means friend of the court. That means to assist the court in discharging these public interest litigation, amicus curiae are appointed. When this amicus curiae was appointed to look into this case, this amicus curiae found out that basically these two businessmen who have filed this case calling for banning of asbestos, they are actually running a factory which manufactures an alternative to asbestos. So basically what they're doing, they're cloaking their personal interest into public interest litigation. And ultimately what Gujarat High Court did, imposed a fine on these businessmen with a warning that if you file these frivolous PILs again, we are going to ban you from filing PILs ever. Similarly, there was an advocate, M.L. Sharma. In 2018, he was imposed with a fine of 50,000 rupees with a warning that it is time to ban you from filing PILs from life. Why? Because he filed a public interest litigation wherein he pleaded before the Supreme Court that please restrain Arun Jaitley, who was the then finance minister of India, from using the capital reserves of Reserve Bank of India. Capital reserves of Reserve Bank of India should not be used by Arun Jaitley. There was a plea in the Supreme Court, and ultimately the Supreme Court dismissed this public interest litigation. That means now the Supreme Court has taken upon itself to prevent the misuse, overuse, and abuse of this public interest litigation. And Supreme Court has listed down various rules. Number one, you cannot cloak your personal interest with public interest. If you do that, we are going to impose penalty on you. And if you persist with doing that, we are going to ban you for life from filing these public interest litigations. Second, whenever a petitioner files a public interest litigation, he has to prove that he is doing this bona fide, in good faith. He does not have any ill intention from filing these public interest litigations. And at the same time, there are certain matters on which public interest litigations can be filed. You cannot file public interest litigation for seeking transfer from one department to another department or from one area to another area. You cannot file a public interest litigation if you have a dispute between a tenant and a landlord. On such frivolous matters, there can be no public interest litigation. But public interest litigation should be filed when fundamental rights are concerned. That is what the Supreme Court has said, and these are the new rules which will enable a good set of PILs being filed in the Supreme Court, which ultimately will help every single individual in this country. That is what you need to understand from public interest litigation. But then there is another related concept called judicial activism. Is it judicial activism or is it judicial adventurism? When PILs have been filed, it is through this power of public interest litigation that the judiciary is practicing something called activism. What is this judicial activism? Judicial activism is such when the courts enter into the picture and force the other organs of the state to play their actual role, forcing the other organs of the state to discharge their duties, forcing the other organs of the state to abide by the Constitution. That means in this judicial activism. And what is this judicial activism? Where Supreme Court or the High Court acts like a social activist and forces the other organs of the state, unwilling organs of the state, to discharge their duties according to the rules of the law. The best example of judicial activism would be Vishaka Guidelines of the year 1997. What are these Vishaka Guidelines? There was one lady, Bamri Devi, in Rajasthan. She belonged to so-called lower caste. She was also the worker of the government, and she would go from one place to another persuading the people in Rajasthan that you should not go for child marriages. You should abstain and refrain from child marriages. And ultimately, some of the upper caste in Rajasthan, they did not agree, and they could not fathom that here is this lower caste lady who is asking us Rajputs, the higher caste people, that you should refrain from child marriages. Ultimately, Bamri Devi was raped in full public view. She was gang raped by 5 individuals. And ultimately, what happened? Matter went to the court, and the court released all these individuals. When court released all these individuals, one of the rationale given by the court was that two accused out of these 5, one is the uncle, the other is nephew. So it is not possible that the uncle would rape somebody in presence of the nephew, or the nephew would rape somebody in presence of the uncle. That is why these 5 accused are set free. When nothing happened, one non-governmental organization, Vishaka, approached the Supreme Court and asked the Supreme Court, is there any mechanism to prevent the sexual harassment of women at workplaces? Because after all, Bamri Devi was working. She was an employee of the government. And while she was working for the government, she was gang raped in full public view. Is there any mechanism in place wherein we can prevent the sexual harassment of women at workplaces? The Supreme Court issued a detailed guideline how we can prevent sexual harassment of women at workplaces. And this guideline came to be known as Vishaka Guidelines. Now you will say, how is this judicial activism? In absence of a law, when there was no law which could prevent and protect sexual harassment victims, the Supreme Court had to enter into the picture, take up the role of an activist, and issue guidelines. This is what we call Vishaka Guidelines, and this is what we call judicial activism. Another example of judicial activism, there is, and there was also a menace of black money in our economy. The then UPA government was asked by the Supreme Court to set up a special investigating team to unearth black money. Since the government was unwilling to do that, ultimately what happened? Supreme Court entered into the picture, took up the role of an activist, and that is what we call judicial activism. Similarly, Board of Control for Cricket in India. There was corruption in BCCI, there was nepotism in BCCI, various other charges of misconduct in BCCI. Ultimately, what Supreme Court did, appointed a committee headed by former Chief Justice of India called Justice Lodha Committee to cleanse the Board of Control for Cricket in India. That is what we call judicial activism. Now you will say, why judiciary is doing this? Is judiciary authorized to play the role of an activist? Number one, judiciary is not happy donning the role of an activist. But judiciary has been forced to take up the role of an activist by the unwilling legislature and executive. How? Lokayukta to Uttar Pradesh was to be appointed. There was a tussle between the then Chief Minister of Uttar Pradesh, Akhilesh Yadav, and the governor. Files went back to and fro from governor's table to Chief Minister's table, and nothing happened. The Supreme Court is repeatedly asking the state government of Uttar Pradesh to appoint the Lokayukta. Ultimately, nothing happened. Then what Supreme Court did? Supreme Court took up this file, which listed down various individuals whose names have been recommended to be appointed as Lokpal, and picked one name from this list and appointed this individual as the Lokayukta of Uttar Pradesh. Now you will say, this is judicial overreach. Judiciary is exceeding its jurisdiction, but judiciary has been forced to take up the role of an activist because the executive has been unwilling. That is why judiciary is not happy playing the role of an activist. But this role of an activist has been thrust into the unwilling throat of the judiciary by a recalcitrant executive and a recalcitrant legislature. That is what we call judicial activism. But is judiciary empowered by the Constitution to practice judicial activism? Perhaps yes. How? Under Article 142 of the Indian Constitution, the Supreme Court has the power that it can issue any order to provide complete justice to the people. And it is invoking this Article 142 again and again and justifying the role of judicial activism. But then there's a very thin line between judicial activism and judicial adventurism, between judicial activism and judicial overreach. And if you violate this line, you are violating theory of separation of powers, and this theory of separation of powers is also part of the basic structure of Indian Constitution. So what can we call judicial adventurism? Let me give you some examples. Number one, PIL was filed in the Supreme Court. Supreme Court issued orders to prevent monkey menace in cities and towns. Okay. Supreme Court issued orders prescribing seat belts. Perfect. Supreme Court issued order that liquor cannot be served within the 500 meters along the national highways. Okay. Supreme Court issued order that all the rivers should be interlinked. Fair enough. The Supreme Court issued orders to prevent a ragging menace in the society. Fair enough. At the face of it, you will say that what is wrong here? To tackle monkey menace, the rules are issued by the Supreme Court, but this is the domain of the executive. Making policy is the domain of the executive. Why are you entering into the domain of the executive? Wearing of seatbelts are prescribed by the judiciary. That is not your job. 500 meters from the national highways, no liquor can be served. This is judicial overreach. How? If 500 meters along the national highways, no liquor is served, what will happen? Court's reason is that there have been too many accidents on the national highways because of the drunken driving. And to prevent this menace of people getting killed in drunken driving, we have to ban the sale of liquor 500 meters from the national highways. But look at the economic costs of it. Economic costs are, there are various 4-star and 5-star hotels along the national highway. They will lose their rating if the bars are banned and closed in their hotels. And look at the cost on unemployment. People will lose their jobs as well. That means without considering other aspects, you are simply giving up a rule, giving up a solution to a problem and saying ban the sale of liquor 500 meters along the national highway. Instead, what you could have asked for, better monitoring, better tests to be conducted on the drivers on the national highway. That is the need of the hour, not blanket banning of the liquor, which is going to affect employment opportunities in this country. And what is this interlinking of all the rivers? This is such a complex task that even engineers will shudder by looking at the prospect of interlinking all the rivers in this country. And Supreme Court is ordering interlink all the rivers. That is how we are going to solve the problems of drought. That is how we are going to solve the problems of water in this country. What are you doing? And at the same time, prevent lagging menace in the universities. This is the domain of executive. If rules are to be made, this is the domain of the legislature. If the law is to be made, why are you entering into the domain of the executive and the legislature? On top of that, Supreme Court once said that we will monitor the distribution of PDS, food grains, to below poverty line families. This led to the then Prime Minister Dr. Manmohan Singh remarking that please Supreme Court, you are entering into my domain. On top of that, there is a shrine in Srinagar called Hazrat Bal Shrine. Militants entered into this shrine, took people hostages, and this hostage crisis continued for many days. Ultimately, the military decided and hit upon a plan that what we will do, we will block the supply of food to the shrine. When we will block the supply of food to the shrine, ultimately we are going to weaken these terrorists, then we can enter into the shrine and kill these terrorists. Matter went to court. Supreme Court said, no, you can't block the food supply to the shrine. Instead, what you have to do, you have to ensure that 1200 calorific value of food should be given to the hostages every single day. This led to the then Army Chief remarking that Supreme Court has interfered in an ongoing military operation, and it has resulted in a lot of loss to the armed forces. So it is in these matters that judiciary should not enter into the picture. This is what we call judicial adventurism, and judges love it. How? A PI was filed that dear Supreme Court, bureaucrats are transferred within 1 year from one department to another department. There is no tenure for bureaucrats in this country. Supreme Court said yes, this is public interest litigation. So what we will do, we will prescribe a tenure. So for DGP, it should be a 2-year tenure. For IGP, it should be a 2-year tenure. Before this tenure expires, you cannot transfer these bureaucrats, these police officers from one place to another. Fair enough. But this is what I call judicial hypocrisy. If the judiciary can prescribe tenure for others, why not to itself? There have been judges appointed to the judiciary, to the High Court and the Supreme Court for 2 months, for 3 months, for 4 months. There was a judge appointed, Chief Justice of Odisha High Court, Justice Bilal Nasri. He was appointed as the Chief Justice of Odisha High Court for 3 days. If we remove the intervening holidays, he was the Chief Justice of Odisha High Court for 1 day. Why was this judge appointed as Chief Justice of India for 1 day and then you are prescribing tenure for others? Why can't you say we will prescribe tenure for ourselves as well? We cannot appoint somebody who has a tenure of less than 1 year or less than 2 years. You appointed Bilal Nasri as the Chief Justice of Odisha High Court because then he would have been eligible to be appointed as the Chairperson of State Human Rights Commission, because you should have been an ex-Chief Justice of the High Court to be appointed as Chairperson of State Human Rights Commission. This is why I call judicial hypocrisy. So what are we talking about in this lecture? I told you what is judicial review. And I told you what is public interest litigation. What is the origin of public interest litigation? What are the good points of public interest litigation? What are the bad points of public interest litigation? What are these new rules which have been implemented so far as PIL is concerned? Then we talked about that it is using this power of PIL that judiciary is practicing something called judicial activism. Very good. In some cases, the judiciary deserves credit for taking up matters of urgent public importance which the executive and the legislature had neglected for far too long. And this is how judiciary is playing the role of an activist. But there's a thin line between judicial activism and judicial adventurism, between judicial activism and judicial overreach, and you should not cross this line. Because if you cross this line, you are violating separation of powers, which you yourself have said is part of the basic structure of Indian Constitution. That is why we say there are some disturbing trends of judicial activism in this country, and these are some of these disturbing trends in judicial activism in this country. Now there's something else called judicial evasion. Till about 1970s, judiciary was practicing called judicial restraint, not commenting upon the policies of the government, but remaining very focused on whether the laws are constitutional or unconstitutional. We won't comment on the policies. Then 1979 onwards, with the emergence of PIL system in this country, now judiciary has embraced the role of an activist. It is hyperactivist everywhere. And now we have also encountered a situation where some people allege that judiciary smacks of judicial hypocrisy as well. But there's another term that is used nowadays with respect to judiciary, and that is judicial evasion. What is this judicial evasion? Judicial activism is judiciary becomes very happy in interfering in a particular matter. Very happy. But there are some issues on which the judiciary is hands off. We will not touch it. How? Section 377. It was declared unconstitutional in 2009 by the Delhi High Court. Then in 2013, Supreme Court said no, it is not unconstitutional, it is constitutional. Why? One of the reasons provided by the Supreme Court was that Section 377 is part of IPC. IPC has been amended more than 33 times since the enactment of our Constitution. But if the Parliament did not deem it fit to delete Section 377, what should we do it? Judicial evasion. On controversial topics, judiciary is not interfering. Although now Section 377 is declared unconstitutional, but at least at some point in time, judiciary was practicing something called judicial evasion. Similarly, on Ayodhya, there's a dispute in Ayodhya on the Ram Janmabhoomi temple issue. Judiciary is not giving any verdict because this is too controversial an issue. This is too sensitive an issue. Judicial evasion. Similarly, demonetization exercise was carried out in 2016 by Prime Minister Modi, and for close to 2-3 years there was no judgment whether demonetization is illegal or legal, whether it is constitutional or unconstitutional. Judicial evasion. That means on sensitive topics, judiciary is practicing something called judicial evasion, and that is something judiciary should carefully ward off this criticism that it is practicing something called judicial evasion. That is what you need to understand from this lecture. In this lecture, let us look at one of the most important topics called crisis in judiciary, and we will take up 2 important cases of 2 Chief Justices, Justice Deepak Misra and Justice Ranjan Gogoi. Now let's take up the origin of this case. There was a medical college in Uttar Pradesh. This medical college was banned by Medical Council of India from carrying on with the admission formalities because of some irregularities, because of some concerns. That means Medical Council of India banned this UP Medical College from carrying on the admissions. Ultimately what happened? The owner of this UP Medical College approached some people, or some people approached the owner of this medical college, bribes for exchange, and ultimately bribes for exchange, so that this UP Medical College would get a favorable judgment from the Supreme Court. One of the persons who was accused of taking bribe was a judge of Odisha High Court. And when this matter approached the Supreme Court said this NCR ruling banning this UP Medical College from carrying on with admission formalities This ruling of NCI is illegal, allowing the UP Medical College to proceed with the admission formalities. The judge who gave this ruling was Justice Deepak Misra, and Justice Deepak Misra later on became the Chief Justice of India. When these bribery allegations surfaced, a public interest litigation was filed by Prashant Bhushan, one of the very famous PI lawyers in this country, and this case was heard by Justice Chalameshwar. Justice Chalameshwar was the senior most judge of the Supreme Court below the Chief Justice of India, Justice Deepak Misra. Justice Chalameshwar thought that since the needle of suspicion points to Justice Deepak Misra, so Justice Deepak Misra should not decide who will hear this case. Instead, what Justice Chalameshwar said, Justice Chalameshwar decided that these are the three judges who will hear this public interest litigation. Okay? That means the bench was constituted by Justice Chalameshwar. Matter went to Justice Deepak Misra, who is the Chief Justice of India. Justice Deepak Misra, what he did, he quashed this bench, said this bench will not hear this case, but instead these three judges or these two judges will hear this case. The petitioner argued that Justice Deepak Misra, since the needle of suspicion points to you as well, it was against the principles of natural justice. They say nobody should be the judge in his own case. So if the needle of suspicion points to you, you should not decide who will hear this case. Instead, Justice Chalameshwar, when he said that this was a much logical bench, this bench should have heard this public interest litigation. But Justice Deepak Misra said, since I am the Chief Justice of India, I am the master of the roster. What is this master of the roster? Chief Justice of India decides who is the judge who is going to hear a particular case, how the judges will be constituted to hear a particular case. Just to give you a few examples, according to this master of the roster, Chief Justice of India decides that if there is a case involving a public interest litigation, these are the judges who will hear public interest litigation. If there is an election petition, these are the judges who will hear election petition cases. If these are tax cases, these are the judges who will hear this case. If this is a land acquisition case, these are the judges who will hear this case. That means allocating benches to various sets of cases. That is the job of the Chief Justice of India, because Chief Justice of India is the master of the roster. So when Justice Chalameshwar set up a bench to hear this public interest litigation, Justice Deepak Misra said this bench is constituted illegally because I am the master of the roster and these judges will hear this public interest litigation. Ultimately, when this bench heard this case, they dismissed this public interest litigation, saying no allegation of corruption is proved. There can be no investigation into this UP Medical College bribery case. When the petitioner argued that their Justice Arun Mishra, who was one of the judges on this panel, who dismissed this PI, Justice Arun Mishra was asked, how can Chief Justice of India constitute this panel to hear a case about himself? Is it not violation of the principles of natural justice, which says no person shall be the judge in his own case? What the bench in this case said, ironically and unfortunately, the judges said this principle of natural justice, which says no person shall be the judge in his own case, it does not apply to Chief Justice of India. So that was one crisis in judiciary where people thought that Chief Justice of India is using the power of being the master of the roster illegally, giving scant disregard. Clear? That is crisis number one. Crisis number two, Justice Loya case. Justice Loya was a CBI judge who was hearing a case involving one of the so-called alleged fake encounters in Gujarat, in which one of the accused was Mr. Amit Shah. Justice Loya was about to deliver verdict in this fake encounter case wherein he mysteriously died. He went to Nagpur to attend the wedding of a friend, and there he had a heart attack and ultimately he died. Many people argued, and Paragon magazine came up with a detailed report that Justice Loya had no history of any heart ailment. So how is it that Justice Loya died because of the heart attack? There's some mystery surrounding the death of Justice Loya. Also, Paragon magazine pointed out that Justice Loya had confided in two individuals that I am being bribed, I am being pressurized to give a favorable judgment in this case so that Mr. Amit Shah can be exonerated. And both these individuals with which Justice Loya shared his concerns, shared the bribery allegations, both these people also died, mysteriously died. Ultimately, when Paragon magazine broke out the story, a public interest litigation was filed in the Supreme Court calling for an independent, thorough investigation into the Justice Loya episode, into the death of Justice Loya. Chief Justice of India, Justice Deepak Misra, dismissed this public interest litigation, saying no allegation is proved, there can be no investigation into the death or the unnatural death of Justice Loya. Then what happened? Four senior most judges of the Supreme Court, Chief Justice of India, Justice Deepak Misra, below him, four senior most judges of the Supreme Court, Justice Chalameshwar, Justice Ranjan Gogoi, Justice Korean Joseph, Justice Madan Lokur, they attended a press conference. They called a press conference and told the people of this country and leveled serious allegations against the Chief Justice of India. One of the serious allegations against the Chief Justice was that there is an allegation of bench fixing. That means bench fixing is going on in the judiciary. What is this bench fixing? That means whenever a case comes, this case, if it is a sensitive case, it is allocated to junior judges. These four senior most judges of the Supreme Court, they are not given important cases to hear. That means most of these important sensitive cases are either heard by Chief Justice of India, Justice Deepak Misra, or heard by junior judges of the Supreme Court. These four senior most judges of the Supreme Court, they are not given important, serious and sensitive cases to hear. So allegation was bench fixing is going on. This led to many people arguing that this was a historic event. A historic, unprecedented event where four senior most judges of the Supreme Court are telling in a press conference that democracy is in danger. They are referring to the misuse of the power of the master of the roster by the Chief Justice of India. They are alluding to the Justice Loya case, wherein these four judges felt that Justice Loya case should have been held, that Justice Loya case should have been dealt with differently. There should have been an investigation by the judiciary into the allegations of foul play in the death of Justice Loya. But ultimately, nothing happened. Justice Deepak Misra continued to be the Chief Justice of India. Then the opposition tried to remove Chief Justice of India by passing a parliamentary resolution, but the chairperson of Rajya Sabha, the Vice President of India, did not even accept this petition, and Justice Deepak Misra continued as the Chief Justice of India. So many people thought that this is one of the biggest crises in the history of independent judiciary in this country. And remember, who was one of the judges who held this press conference? Justice Ranjan Gogoi. And Justice Ranjan Gogoi was then all set to be appointed as the Chief Justice of India. Now let me tell you something very important here. How is Chief Justice of India appointed? The senior most judge of the Supreme Court is normally appointed as the Chief Justice of India. This is what I have communicated to you in the past. But the convention is that the outgoing Chief Justice of India would recommend the name of his successor. And this person shall be appointed as the Chief Justice of India by the President of India. So many people thought that since the outgoing Chief Justice of India is Justice Deepak Misra, who is next in line to be appointed as the Chief Justice of India, Justice Ranjan Gogoi would not be recommended by Justice Deepak Misra to be appointed as the next Chief Justice of India. But contrary to all the speculations, Justice Deepak Misra, the outgoing Chief Justice of India, recommended the name of Justice Ranjan Gogoi as the next Chief Justice of India, and Justice Ranjan Gogoi was appointed as the Chief Justice of India. The many people thought that under the Chief Justiceship of Justice Ranjan Gogoi, there will be some reform in the master of the roster, there will be some reform in the judiciary. Then came a heartbreak. What was the heartbreak? Justice Ranjan Gogoi, in Supreme Court, there used to be a lady who was working as a clerk in the Supreme Court. After that, this lady was transferred to the residence of Justice Ranjan Gogoi. She would assist Ranjan Gogoi at his residence. Ultimately, what happened? This lady wrote a letter to all the judges of the Supreme Court alleging sexual harassment at the hands of Justice Ranjan Gogoi. So serious charges of sexual harassment were leveled against Justice Ranjan Gogoi. And ultimately, what happened? Then what happened? Next day, when some of the news portals, they published this newspaper report about the sexual harassment allegations against the Chief Justice of India, Justice Ranjan Gogoi, along with two other judges, they held an unprecedented hearing in the Supreme Court. And in this hearing of the Supreme Court, Justice Ranjan Gogoi is dismissing all the sexual harassment allegations against himself, tarnishing the image of the lady who has leveled these allegations, and after that he is saying that now these two judges will decide whether these allegations are correct or incorrect. These two judges will hear this particular case. But the point that many people raised at that point in time was that is it not violation of the principles of natural justice, which says nobody should be the judge in his own case? When Justice Ranjan Gogoi addressed a press conference against Justice Deepak Mishra, he leveled the same allegation that Chief Justice of India is violating his powers of being the master of the roster. Today the same allegations are leveled against Justice Ranjan Gogoi. And ultimately what happened? This lady was then promised that we will set up a committee and we will look at the allegations against the Chief Justice of India. But when 3 members of this committee, a panel of 3 judges was set up, and ultimately this lady was not even allowed to have a lawyer. This lady was not allowed to even have a support member who could have assisted her while these 3 judges would investigate these allegations. This lady said, I have a problem with my hearing. I cannot hear properly, so I need someone who can assist me while this investigation is going on. But she was refused. And ultimately what happened? This lady recused herself. This lady said, I'm not going to participate in these investigations now. And ultimately a clean check was given to Justice Ranjan Gogoi. All the allegations against Justice Ranjan Gogoi were swept under the carpet. This led to the former judge of the Supreme Court, Justice Chalameshwar, say that this lady has not been treated well by the judiciary. When clean check was given by these 3 judges to Ranjan Gogoi, this lady asked, please give me the copy of your verdict. Please give me the copy of this ruling. But even this copy of the ruling was not given to this lady. And ultimately that is what we call the crisis in judiciary. So how can we solve this problem? Many people thought that Ranjan Gogoi, as the Chief Justice of India, would at least initiate some of the far-reaching reforms in the judiciary concerning the master of the roster problem. But ultimately many people argued that he proved to be worse than Justice Deepak Mishra. So what is the solution to this master of the roster problem? Let's look at the solution. There is no denying the fact that Chief Justice of India is the master of the roster. But this power of being the master of the roster has been misused by various chief justices in this country. But now one question waiting on your mind, is it also a problem in the United States? Is it also a problem in the United Kingdom? No, it is not a problem in these 2 countries. Why? In the United States, all the judges of the federal court, they sit together. They hear a particular case together. So there is no element of bias. In India, what happens? There is a case on election dispute. Chief Justice of India will decide these 3 judges or these 2 judges will hear this case. What about the remaining 27 judges? They are given separate other works as well. Since in India, we hear a particular case in a judge bench of 2, 3, 4, 5. That is why there can be a situation where master of the roster power is misused or can be misused by Chief Justice of India. In the United States, it cannot happen because all the judges of the federal Supreme Court, they sit together and hear a case. In England, 5 or more judges or 8 judges, they sit together. So there can be no element of misusing the power of being the master of the roster by Chief Justice. But in India, since benches are constituted in numbers of 2, 3, 4, 5, there is an element and there is a suspicion that this power of the Chief Justice of India, when Chief Justice of India is the master of the roster, this power is being abused, misused, and overused by the Chief Justice. So what can be the solution? The solution is we can use a software program. What is the software program? That means whenever a case is filed, this software program will automatically choose a bench which will hear this case. So there can be no allegation that manually Chief Justice of India is deciding which bench should hear this particular case. So the element of bias can be completely removed. If you're saying that the software program can also be manipulated, that should be the question on your mind. We have another solution. What is the solution? Divide the judges into the areas of their expertise. For example, there can be a judge who is well versed with taxation matters. All taxation matters should go to this judge. All land acquisition matters should go to another judge who is well versed in land acquisition laws. If there is a case involving election disputes, this should be heard by a particular judge bench because these are the judges who are well versed in election disputes. This is the other solution that we can have. And at the same time, when we say collegium system recommends names to the president of the individuals who are to be appointed as the judges of the Supreme Court and High Court, why can't we have a situation where important sensitive cases such as public interest litigation, such as election disputes, such as sexual harassment cases should be heard by Chief Justice of India and 4 senior-most judges of the Supreme Court? That means important sensitive cases should be heard by the collegium itself. This is how we can eradicate the bias and it will go a long way in enforcing people's faith in this very important institution called the judiciary. That is what you need to understand from this topic, crisis in judiciary. Now let us look at high courts in this country, but we will look at high courts very briefly because for this examination we have to focus more on Supreme Court and not on high courts. But there is one important topic from high courts that we need to understand in detail and that we are going to discuss towards the end of this lecture. And I will tell you how high courts in this country have been subject of relentless attack, not just by the Supreme Court but also by the Parliament. And that is how we will have to understand the relevance of high courts in this country, but that is something we will discuss towards the end of this lecture. So far as high courts are concerned, today we have 24 high courts in this country. That means Constitution says there should be a high court for every state. That doesn't mean that there should be one high court for one state. Clear? That means we can have one common high court for different states in this country. That is why for 29 states and 7 union territories we have 24 high courts in this country. But what about the composition of these high courts? Composition of these high courts, the Constitution has left to the president. That doesn't mean president has all the authority to decide how many judges should be there in the high court. It depends upon the advice given by the Council of Ministers. It also depends upon the requirements in a particular high court, depends upon the workload in a particular high court. But so far as Supreme Court is concerned, Constitution has explicitly stated that there shall be a Supreme Court at Delhi and it will consist of Chief Justice of India and not more than 7 judges. Originally, now the system is we have a Chief Justice of India and 30 other judges. That means Constitution says how many judges should be there in the Supreme Court. Parliament will change the number of judges of the Supreme Court as and when it is required. But so far as the composition of a high court is concerned, it is left at the discretion of the president. President determines what is going to be the composition and the strength of a particular high court. What is the qualification required for somebody to be appointed as the high court judge? We have discussed that. How the judges are appointed? We have discussed that. How the judges are removed? We have discussed that as well. So if you look at the hierarchy, we have Supreme Court at the top, followed by the High Court, and then we have a District Court. When you look at this District Court is sometimes referred to as District and Sessions Judge or a Sessions Court. And the judge who presides over District and Sessions Court is referred to as District and Sessions Judge. What is the difference? If a judge is hearing a civil case, this judge is referred to as District Judge. If a judge is hearing a criminal case, this judge is referred to as Sessions Judge. And how are these judges appointed? In most of the states, there is a well-defined examination pattern where the State Public Service Commission conducts an examination and recruits these judges to district courts. And then over a period of time, some of these judges are promoted to the high courts. And over a period of time, some of these judges of the high courts are promoted to Supreme Court as well. That is what you need to understand from high courts in this country. You don't have to dig deeper into high courts because from Philip's perspective, this is what you require. And from Main's perspective, I will give you a very important question at the end of this lecture that you'll have to keep in mind and we will discuss the relevance of high courts in this country. But in the beginning of these lectures, I told you in the beginning that we have a 3-tier structure of constitutional courts in this country, Supreme Court followed by High Court, then District Court. But now in 2009, a 4th tier has been added, Gram Nyayalayas. What are these Gram Nyayalayas? For that we have to understand alternate dispute resolution. That means if we have to resolve a dispute, is it that we have to always go to the judiciary and knock the doors of the judiciary? Can't there be alternate methods of dispute resolution? Yes. What are these alternate methods? Number 1, use the offices or good offices. What does that mean? For example, these are two sets of villages. Now, an electric transformer is to be installed. The people from both the villages are fighting with each other. One set of people are saying that this transformer should be fixed in our village. Other set of people are saying that this electric transformer should be fixed in our village. And then these people are fighting with each other. Then there is a dispute. And normally they approach the judiciary, they approach the district court. Why can't we use the good offices of a district collector? So that this district collector, whose office is treated with respect by the people of these villages, we can involve the district collector, and district collector can use his good office to solve this problem between two villages. And ultimately the problem is resolved, and this case does not enter into the judicial system. That is how we can have an alternate method of dispute resolution. Another alternate method is arbitration. For example, family disputes. For example, rental disputes between landlord and the tenant. For example, property disputes. There are two individuals. They both fight with each other. For example, husband and wife. They fight with each other and they want to go for a divorce. They want to opt for a divorce. And then they go and file a case in the judiciary. Can't we use an arbiter? So that this arbiter, who is a third party, who is not connected with either husband and the wife, but this third party, arbiter, will dispassionately hear the arguments of both husband as well as the wife, and then come to a conclusion, come to a result, come to a verdict. And this ruling of this arbiter should be binding on both the parties. That means ultimately, arbitration can be another alternate dispute resolution mechanism, wherein we can use an arbiter, a third party. He will look at this dispute dispassionately because he's not connected to either of these two parties, and will issue a ruling, and this ruling is binding on both the parties. And that is where we need to understand the functioning of these Gram Nyayalas as well as Lok Adalats. When in 2009, Gram Nyaya Act was enacted by the Parliament, the objective was that we have a Supreme Court at the center, we have High Court for every state, we have District Court for every district. Now we should have one court or a judicial office in every single village in this country. So that this office or this judicial office will serve as a Gram Nyaya. So that inexpensive, quick justice, swift justice is provided to the people of these villages. That was the objective of Gram Nyayalas. But the point is, isn't it expensive to set up a judicial office in every single village in this country? Number one, it is required because it is for the betterment of the people. But at the same time, yes, it is expensive. So government initially thought that we should have these Gram Nyayalas as mobile courts. That means there should be a vehicle. In this vehicle, the judge will be present, clerks will be present, who will assist the judge, and then this mobile judicial office will move from one village to another village and impart justice to the people of these villages. That was the original idea of these Gram Nyayalas. And these Gram Nyayalas would initially function as arbitrary. Section 89 of CRPC provides legal sanction to these alternate dispute resolution mechanisms. Initially, these Gram Nyayalas would function as ADR, alternate dispute resolution mechanism, and it is only when one party decides, I will not abide by the decision of this arbiter, it is then that this Gram Nyaya would act as a regular court. That means originally the thought was that we should set up Gram Nyayalas at every village in this country, so that quick, inexpensive justice is provided to the people of this country. Clear? But then policymakers thought that it can be expensive as well. So they thought, let's have these Gram Nyayalas as mobile courts. Even then the policymakers thought that people will have to pay fees, judicial fees to Gram Nyayalas, so it can deter them from seeking justice from Gram Nyayalas. So what policymakers thought, initially these Gram Nyayalas would function as arbiters. That means you have a marital dispute, you approach a Gram Nyaya. Initially what we will function as arbiters. I will hear your story, I will hear your story as well, and at the end I will give a ruling. And this ruling is binding on both of you. But if tomorrow, at some point in time, one of the individuals, either husband or the wife, they decide to come out of this arbitration, they decide to not pursue arbitration, then what will happen? This Gram Nyaya would function as a court. And as a court, I will give an order, and this order is binding on both the parties. That was the original proposal, original idea behind these Gram Nyayas. Then what are these Lok Adalats? Lok Adalat primarily means people's court. In Lok Adalat, there are three members. There is one sitting judge or a retired judicial officer who acts as the chairman of Lok Adalat. Second member is an advocate. Third member is a social activist. Look at this beautifully. It's a very, very beautiful concept. Lok Adalat, people's court. There is a party A, party B. Normally what happens, if they have a dispute, they approach district court. But in district court, they have to pay fee, judicial fee. They have to pay fee to their lawyers as well. And this is not only expensive, but at the same time, this is also time consuming. Because you will get a date of hearing today, and the next date of hearing will be after 10 months, after 12 months, after 2 years. Inexpensive, expensive, but at the same time consuming as well. So alternative is, instead of approaching the judiciary, approach this Lok Adalat. And in Lok Adalat, you don't have to pay any fee. In Lok Adalat, there is no need to have a lawyer. Even the lawyers are not allowed. And if you have a case pending in the district court, you can withdraw this case from the district court, file this case in a Lok Adalat, and this fee will be refunded to you. So many benefits if you are filing a case in a Lok Adalat. But unfortunately, not many people are aware about it. Not many people are aware about it, and they do not opt for justice mechanism through these Lok Adalats. And that is why the government needs to popularize the concept of Lok Adalat. Two more important things. Lok Adalats can only take up civil cases. They can't take up criminal cases. And bulk of these civil cases related to motor vehicle insurance, marital disputes, so on and so forth. The only criminal case that is taken up by Lok Adalat is a check bounce case. If your check bounces, for example, I've given you a check of 1 lakh rupees, but then there is no money in my account. Then you go to the bank and ask the money through this check. They say that there is no money in my bank account. Ultimately, the check is bounced. It's a crime. And this is the only criminal case that is heard by a Lok Adalat. That means what are we talking about? We are talking about alternate dispute resolution mechanism. Instead of going to the judiciary, there are other options available to us. We can use good offices, we can use Gram Nyayalas, we can use Lok Adalats as well. Clear? And these Lok Adalats are working effectively in some parts of the southern India. But in northern India, they are not as popular as in South India. That is why additional steps, additional revenue, additional funds should be made available to the state governments so that they can set up Gram Nyayalas, so that they can set up these Lok Adalats as well. Initially, Gram Nyaya would function as some sort of a Lok Adalat. But Lok Adalat only takes up civil cases, Gram Nyayalas can take up criminal cases as well. But initially, Gram Nyaya would function as arbiter, dispassionately looking at both sides of the story, then giving an order. But if one side decides to withdraw from arbitration, then this Gram Nyaya would function as a regular court, will issue a judicial verdict which is binding on both the parties. That is what you need to understand from this alternate dispute resolution mechanism. Now let us raise a very important question. Why is justice delayed? And to use the cliche, justice delayed is justice denied. If you look at pendency of cases in this country, look at our high courts. There are more than 44 lakh cases pending in high courts in this country. If you take up Supreme Court, high courts and district courts together, there are more than 3 crore cases pending in different courts in this country. Justice delayed is justice denied. What are the reasons? Why are there so many cases pending in different parts of the judiciary in this country? We can break down the reasons for the same under 3 categories, under 3 heads. So there are 3 reasons why there is a huge pendency of cases in different courts in this country. Number 1, there are too many lacunas and loopholes in our laws. If you look at our laws, there are loopholes, there are gaps in these laws, so that tomorrow if there is a dispute in the interpretation of this law, we end up filing a case in the judiciary. Look at our property rights laws. Look at our tenancy rights laws. There are so many glaring loopholes, so many lacunas in these laws that people end up filing a case in the judiciary. That's one big reason, because our laws are not fine-tuned. Our laws, the legal language used in our laws is not foolproof, and that is why there are cases filed in the various courts in this country. That's number 1. Number 2, legal proceedings are themselves so complicated and ill-defined that the rate of clearing of cases is abysmally low. That the rate of clearing of these cases is abysmally slow. This has been immortalized by Sunny Deol, now the member of the parliament from Gurdaspur constituency of Punjab. He made a passionate speech in one of his movies when he said, Tariq pe Tariq pe Tariq. Look at judges in this country. They give adjournments on silly reasons. Look at our lawyers. That's how, please adjourn today's proceedings because I have a marriage to attend. Please adjourn today's proceedings because I have to drop my daughter to the airport. Please adjourn this proceeding because I have some other work or I have some other case. Sometimes, if I'm a lawyer, my assistant would approach the judge and say, please adjourn the proceedings of this case because our lawyer is busy somewhere else, or he is sick, or he is not feeling well and cannot attend to court while I'm attending another case in a different court in this country. So it is because the judges in this country give adjournments on silly reasons that on average, in case of 50 hearings, on average, there would be 10 to 15 adjournments. And then there's a huge gap between one hearing and the second hearing. If today I got a hearing of my case, the second date would come after 12 months, after 30 months. There have been multiple stories in the newspapers where an individual got a hearing in the case, but this individual is dead. And he's dead for a decade now. That is another reason why we have so many pendency of cases in this country. Then there is a third reason. There is a huge shortage of judges in this country. Despite the legislative system, we have not been in a position to fill the vacancies in the high courts. Despite the fact that we are one of the largest democracies in the world, we still have huge vacancies. Despite the fact that we are one of the largest democracies in the world, we have a huge shortage of judges in the lower judiciary. On top of that, if you look at the percentage, India has only 10.5 judges per million population. And what is the result? The result is too many cases are filed every single day. The number of judges are less. Ultimately, the cases get piled up. And these are the reasons why there is a huge tendency of cases in our judicial system. Look at the global practices. We can absorb some of these global best practices. For example, in Scandinavian countries, for example, in Sweden, in Iceland, in Norway, before filing a case in the court, I have to opt for alternate dispute resolution. For example, arbitration. For example, mediation. You will be a mediator between him and me. You will try and solve our problem through mediation. That means before I can file a case in the court, in a regular court, I should opt for alternate dispute resolution mechanism. Ultimately, what is the benefit? The benefit is that most of these cases are solved at the arbitration level, are solved at the mediation level, and ultimately, not many cases are filed in the regular courts. That is something that we should also follow. In your economy lectures, you will be taught about Arbitration and Conciliation Act, and that is one of the most important pieces of legislation that helps in businesses as well, that you have to focus on. One more thing, in Australia, there is a provision for electronic filing of cases, which results in quick filing of the cases, quick justice as well. That is something that we should absorb in India as well. Use of technology in the judicial system can make the entire system much more efficient and will result in speedy trials as well. For example, we still type our judgments using a typewriter, and then if I have to ask for a case file from Karnataka High Court to Supreme Court of India, it takes a lot of time. Why can't we use the technology where the case file will be dropped on the server of the Supreme Court of India, and the Supreme Court judges can read the judgment, can read this case file without having to get the physical copy of this case file? Why can't we integrate technology in our judicial structure? That is something that we should follow. Also, in some countries, there's a provision called discovery system. What is discovery system? I'm a lawyer, you are a lawyer. You are representing your client, I'm representing my client. Suddenly, you came up with evidence. When you came up with evidence, now I have never gone through this evidence. For example, you came up with a call record, you came up with some evidence. I'm requesting the judge, please adjourn the proceedings of this case because I have to go through this evidence. There is a provision in various countries where evidences are shared before the case is heard by the judge. That means all your evidences, I will look at them, all my evidences, you will look at them, so that tomorrow, just because I have to go through this evidence, I should not ask for the adjournment of this case. That is how we can speed up the disposal of cases in this country. That's another solution to our problem in pendency of cases. Over the years, there have been various commissions and committees that have given multiple reports, multiple suggestions about what we should do to solve the problem of pendency of cases in the judicial structure. And let me recap all those recommendations in a very quick format. Recommendation number 1, constitute more number of benches. That is the need of the hour. Second, increase the number of judges. If our ratio today is 10.5 judges per million population, it should increase to 50 judges per million population. That is something that we have to do. Third, computerizing the entire judicial process. And fourth, and very important thing, bunching of similar cases and conducting their hearing under one bench. That means if there are 10,000 land acquisition cases pending, why can't we club all these cases together and give one ruling? If there are motor vehicle insurance cases pending, why can't we club all of them together? Because they raise one common issue, because they raise one common question, because they raise one common strand. Club all these cases together, let one bench hear this particular case and issue an order. That is how, through innovative methods and mechanisms, we can solve the pendency of cases in this country. But unfortunately, nobody seems listening. There was a Times of India report which said if all the judges in this country would work 24/7 without taking a day off, without going for holidays, it will still take 15 years to clear the backlog of cases in this country. And that will mean a death knell to our constitutional system, because justice delayed is always justice denied. These are the solutions that you can write in your answers to solve this problem of pendency of cases in this country. Now, before we end this discussion on judiciary, let's raise a very important issue so far as high courts are concerned. When we discussed high courts, I told you that there is one important issue related to high courts that we will discuss, but towards the end of this lecture. And that is, the jurisdiction of our high courts has been subject to relentless attack by our parliament. How? The framers of our constitution, they gave a very important place to high courts in this country. They thought that high courts in this country can adjudicate all types of cases in this country. And in the initial years of our republic, high courts did play a very important role. For example, in 1951, I told you constitution was amended for the first time when ninth schedule was added to the Indian constitution. Right? Do you know what was the trigger of this constitutional amendment? The trigger was that Patna High Court had declared that Land Reforms Act is unconstitutional because it violates fundamental rights of the people of this country. So high courts played a very important role in the initial years of our republic. And this was according to the belief of the constitution makers who thought that high courts will take up all important cases before these cases are to be taken up by the Supreme Court. Now we have seen that there's a problem. Now what we have seen that the jurisdiction of our high courts is under relentless attack by the parliament. Now what we have seen, the jurisdiction of our high courts is under relentless attack, particularly by the parliament. And how? Because of rampant tribunalization. What are these tribunals? We will discuss in detail towards the later part of our lectures, but very briefly here. Tribunal is a body which is set up for a specific purpose, and this body has been given some judicial powers as well. For example, the idea was that there are some technical cases, for example, income tax cases, for example, environmental cases, for example, cases related to the Companies Act, cases related to Securities and Exchange Board of India. These are cases involving technical nature. But our judges, they are well versed in the law, but they may not be well versed in taxation matters. They may not be well versed in company matters. They may not be well versed in environmental matters. So what we should do? We should set up a tribunal for one specific purpose. So there will be a tribunal on income tax matters. There will be a tribunal on environmental matters, for example, National Green Tribunal. And National Green Tribunal would have members who are experts, as well as members who are from judiciary. So that if there is an environmental case, instead of this case going to a High Court or a Supreme Court, this case should be filed in the National Green Tribunal. Since National Green Tribunal consists of experts as well as judicial members, this NGT would be in a much better position to give a ruling on environmental matters. That is how tribunals were created. But today there is mushrooming of tribunals. There is rampant tribunalization. And this rampant tribunalization raises three important concerns. Concern number 1, Who are the members of the high courts? Who are the judges of the high courts? They're appointed by the president on the basis of the recommendations of the collegium system. That means they have some independence, they have some autonomy. But who are the members of these tribunals? They are appointed by the executive, and they are under the control of the executive. So the members of the tribunal owe their allegiance to a ministry, owe their allegiance to executive. But members of the high court owe their allegiance to the constitution. They are much more independent than the members of the tribunals. That is one issue. There is another issue. These tribunals are not as accessible as high courts. For example, NGT, National Green Tribunal, it has only 4 benches throughout the country. But high courts are available for every state. That means this tribunal, let me give you another example. For example, there's a securities appellate tribunal. If you're not satisfied with the order of SEBI, what you can do, you can file an appeal before the SAT. You don't have to file an appeal before the high court, you have to file an appeal before the SAT. But the SAT office is in Mumbai. So if there's a shareholder from Northeast, or if there's a shareholder from Kerala, instead of approaching their respective high courts, they have to come to Mumbai. Then what they decide, let's not approach this tribunal. So it is expensive justice, it is also denial of justice as well. So that is one problem with our rampant tribunalization. The second problem is, when you're not satisfied with the award of a tribunal, then what you can do, as an aggrieved individual, you approach the Supreme Court. You bypass the High Court. When you bypass the High Court, then what happens? Pendency of cases in the Supreme Court increases day by day. Backlog of the cases increases day by day because you are bypassing the High Courts. On top of that, there's a third important fundamental problem with this, why we should not relentlessly attack the jurisdiction of the High Court. Who are these High Court judges? These High Court judges, High Court becomes, for these judges, a training ground, so that they can tomorrow become respectable, honorable judges of the Supreme Court. But SEBI-related cases don't come to High Court. Companies Act-related cases don't come to High Court. Income tax-related cases don't come to the High Court. National Green Tribunal-related cases, they don't come to the High Court. Then how are these High Court judges going to train themselves so that they can become responsible, good judges of the Supreme Court tomorrow? These are the 3 problems, and that is why there can be a question tomorrow in your mains examination, which is the jurisdiction of our High Courts has been subject to relentless attack by the Parliament. Please explain, and you can give these examples. But not just the Parliament. The High Court's jurisdiction is under relentless attack of even the Supreme Court. Because when petitions are directly filed in the Supreme Court does not tell the petitioner that you should have ideally gone before the High Court. Why are you coming directly to us? That means when petitioners bypass the High Court and directly approach the Supreme Court, and Supreme Court accepts these petitions, Supreme Court is also, maybe unconsciously, but attacking the jurisdiction of High Courts as well. This needs to stop. Because High Courts, as envisaged by the Constituent Assembly, as envisaged by the makers of our Constitution, High Courts play a very important role in dispensing justice to the people of this country. And this relentless attack on the jurisdiction of High Court must stop now and now. That is what you need to understand from this chapter, Judiciary.